Motion, restoration application. Yes, hand over the slip. It will appear in under the heading application in the next monthly list.
May I be permitted to mention one matter for withdrawal of this writ petition with a leave to file and the phrase matter, since matter, joint writ petition has been filed by my let the matter be appear under the heading. I wants to.
It is appearing in the list.
No, my lord.
11 July.
My lord, item regarding item
To be mentioned 11 July. Yes.
item 1143. I'm praying for upgradation upon notice to the other side. I'm mentioning, my lord, my pay scale has not been fixed properly, my lord, that there are teachers, they are not getting their salary in terms of the latest ROPA.
You are getting salary, wait for some time.
One
Fixation of pay scale is not an urgent matter.
one more, my lord, this is a hearing matter. If your lordship kindly releases it, so I can try before the appropriate bench.
Hearing matter.
There is another matter, 2551 item number.
So you want release?
Yes, because my lord, your lordship has considered this. There's a direction for exchange of affidavit.
Tomorrow for release.
Yes, this is
that postgraduate scale of pay matter. Correction is regarding the publication of result. It has been recorded in my writ petition on 6th March. It has been recorded in the order sheet, but in place of 6th, it would be the 7th of March.
So in your writ petition, what does writ petition say?
6th.
So then there is no mistake. You have to make an application.
Document is that.
No. You have to make an application. Sorry. There is no mistake. The order has been transcribed in terms of your amendments made in the writ petition. Yes. Yes, your
provisional, your lordship direction or provisional change started, madam. They are, your lordship, they are complete, madam, audit report, madam, they have stopped,
madam. Have you filed a fresh writ petition? Then
in that writ petition, madam, they have stopped. No, as per, I can't see your lordship, madam. They have submitted, madam. So much your lordship.
There is a direction that matter is appearing at which serial number? But there is no direction for giving releasing provisional pension.
They have already stated, man. In earlier order, man, they have. Earlier order, they have started. Another they have started the.
Yes.
On a second, they have.
So for which period you have received provisional pension? 2 years.
Yes.
That's why provisional pension is paid for a period of 2 years. If further prayer is made, you have to take necessary steps. Yes.
It is college matter, 1020.
College education.
Yes, college.
Tomorrow.
It was considered by the honorable
Is a transfer matter? Transfer. I am not upgrading any transfer matter. Sorry. Yes. No, sorry. Whatever may be. Yes.
I was paid for leave before I am a non-completed candidate, my lord, in 2016, my lord, secondary high level exams. And subsequently, my lord, in upper primary level, my name has been recommended. I applied before the I applied with this clause for verification. Then I paid for time. Within 90 days, my lord, I made an application with this clause, which I can't get. That took some time because the matter is.
What is the urgency?
Then, my lord, within 150 days, my lord, I made an application.
For which post?
Upper primary, my lord, assistant teacher.
Wait for some time. Yes.
No. If that post is filled up, my lord, I will know.
What can be done? Already upper primary selection process is complete.
My name has been recommended. My name has been recommended. My lord, I called for.
You have lost the job in terms of the order of the Supreme Court. Yes. So you have to wait for some time. Yes. Yes. So we want inclusion contempt monthly list under the heading contempt. Yes.
Kindly, this is a restoration application filed within time.
Yes. Under the heading application.
But
monthly
I'm
list of
mentioning,
August.
my lord, two matters, my lord, the SSC requirement, my lord has allowed this matter, my lord, and directed to appear today, my lord, but it is not appearing, my lord.
File.
My lord, I have bring the file, my lord.
Let me see. Let me see. Let the other matters be taken up. Today's matters. Yes.
My lord, may I hand over the, my lord?
No, no. You take steps. File as if file up.
My lord, file has come, my lord, on 10th.
This will be accommodated. Yes.
Yes, your lord.
Item number 86, my lord. My lord, the petitioners, my lord, are being deprived of participating in the SLST process, my lord, 9, 10, 11, 12, my lord. My lord, whereas all the universities has completed their examinations and publishing the results, my lord, but in case of the petitioners, they are not doing so, my lord. My lord, the last
Result of which examination?
B.Ed, my lord.
Result of PED is not coming under my determination.
My lord, SLST process, my lord, 9, 10, 11, 12.
Maybe, but result of PED is to be published by which authority? Yes,
My lord,
it
according
relates to higher education.
higher education.
Unless and until a candidate obtains higher secondary completed higher secondary course, he cannot take admission in BEd course. Sorry, yes. When petitioner retired? When petitioner retired?
Died, my lord, June 2024, my lord. Son of the petitioner died. Issue left.
So when you have filed the writ petition?
January, my lord. Justice Basu passed an order in the month of February, my lord, 13th February, directing the state advocate to submit a report and directed the matter will appear in the month of April.
You are the teacher, your son has died.
Mother, my son died during service. My son
So
died
when the as per last order matter was directed to appear?
April 2020.
April 2024.
Sorry, April 2025. April 2025. And now,
It is not appearing in the list.
yes, my lord, happened. 177,
17?
72,
Yes, under the heading motion primary.
4, primary.
Under motion primary, it is fairly at the top.
Retirement benefit. Mother, my lord. Retirement benefit. My lord, Justice Basu directed the state advocate to submit report.
Well, 16 July.
My lord, I want to mention, proceedings is different.
Follow the procedure. Yes.
You are given a provisional certificate. Now the last option, Mr. Bhaskar says that the excess of color.
What do you want?
It is was returnable on 25th for a daily. Can you improve this in that?
No, if it is not very urgent, please don't. Matter relates to a higher category scale of pay, wait for some time.
If I get the certificate, then only I can pay for higher.
Wait for some time. Yeah, Mr. Lyre is not an urgent matter. Let it appear in the monthly combined list of August. Yes. No, I am not tagging any matter. Sorry. Yes. Sorry, it is appearing as item number 122. You see other matters, what happens, and then you to mention. You wait, other matters are also, I have not included all matters. I have not included all matters. Wait for some time, let the other matters be taken up. Yes.
My lord, this is an application for transfer.
Disturb this court.
This is an application for transfer pending since 2023, my lord. The petitioner is suffering from thyroid cancer, my lord.
Transfer.
Yes, my lord.
When transfer application was made?
In 2022 itself, my
Yes.
lord.
Wait for some time. Yes.
I'm praying for inclusion. Assigned matter, my lord. Assigned matter, inclusion, my lord, for inclusion.
Assign.
Yes, my lord.
কি assign matter দেখো তো?
One issued by Honorable Justice
ওই দুটো
Kaushik
matter?
Chandra and
Next Monday করে দাও। Under the heading assigned. To be mentioned assigned. Yes. Application for restoration. Next monthly list under the heading application. Yes.
My lord, may I be also able to mention this matter as listed motion, my lord, let it be included in the monthly list of August. Is regarding
Which year?
my lord, 2024.
Monthly list of August.
Man, deeply apart.
Yes. Yes.
Item number 9.
Yes.
And this list of 100.
Very well, other same matters are there. Let these matters be taken up. Whatever order will be passed, that will govern other matters. Wait for some time. Yes. I have disallowed others. We have to wait. Then other matters will be taken up. Yes. Yes. New motion of which year? 2025. So the must secondary or primary? Primary. Then when the last order was passed? Because before this court matter comes in terms of presentation form. When the last order was passed and what was the order? Ascertain and then mention on next week. Yes.
For correction, Lordship, when
Correction. What correction is required?
the date is instead of 2014, it's ordered in 2024, Lordship.
What is the date of order?
3rd July, Lordship.
3rd July. Day after tomorrow to be mentioned for correction.
Lordship.
Upgradation, my lord.
What is the urgency?
New motion, my lord. 2155 item number, my lord. My lord, petitioner is a assistant teacher in the CBSE board control primary school. She has been prevented from discharging his duty as assistant teacher.
From which date he is being prevented?
October 22.
2022 October.
October 24.
Wait for some time. It's not an urgent matter.
Finally, his ward, his juvenile son's education has been
Wait for some time. I am
May I permit to mention one matter? May I permit to mention one matter for release, my lord?
Yes, please don't disturb at this point. I am not convinced. So far the urgency is concerned.
May I
Yes.
permit-
Yes. Yes, please allow him.
May I permit to mention one matter for release, my lord? Item number 1612 of the monthly list of July.
Why?
My lord, the similar matter has been released by your lordship on 13/9/2021 on your personal account, my lord. Similar matter, my lord.
House rent matter.
No, my lord. It is a DPSC North Chobbish Pargana selection process 2006, my lord. Similar matter has been released, my lord, on 39/2021, my lord.
Who is appearing for other side?
DPSC North Chobbish Pargana, my lord.
Serve notice and then mention.
I have served notice, my lord.
Who is the learned advocate?
Pinaki Bhattacharya.
Pinaki Bhattacharya. Next Monday to be mentioned for release.
Faithful man. And then, my lord,
No further mentioning, sorry. Long back I have passed order. Now you are coming for correction. What correction is required? Show me the order. Even then this correction is required. It's a trivial issue. Make an application. After such a long time, June order was passed. Make an application for correction. Yes. Yes. Yes.
Under the heading.
When it will reach, then I will pass an appropriate order. Yes.
Lordship, may I be permitted to mention one matter for upgradation, Lordship? Item number 1514 from the monthly list. Petitioner is a cook cum helper in a high school under the midday meal scheme, and she has not been allowed her wages since more than a year. And when she made a complaint before the concerned authority, she has been terminated unlawfully, Lordship, and she is unable to do her son's treatment.
So at this point of time, upgradation is not possible, because for a period of 1 year she was without salary, and it's a case of termination, matter has to be heard. Yes.
Restoration application.
Restoration, hand over the slip. Monthly list of August under the heading application. Yes.
I am mentioning this matter upon notice to the other side.
Yes.
This is item number 1570 of today's list. It is under the motion 4. It is written to date examination. What happened? Inadvertently.
When at which serial number matter is appearing?
It is in 1570 of today's list, today's monthly list. 1570. The additional marks have been wrongfully deducted from my aggregate number. As a result, I am nowhere. Had it not been deducted, then I.
So what is the urgency?
It is, I am out of employment. 2 lists have been published.
From which date you are out of employment?
I have filed this matter.
No, from which date you are out of employment?
From the very beginning. I have
From the
not
very
yet-
beginning means? From 1905?
I have not yet called for interview due to the mistake on behalf of the primary.
Wait for
education
some
board.
time, yes.
This is my lord regarding that school. Just the gentleman just mentioned in matter. Recognition has been granted, but one girl student who is in class 10, her registration, my lord, has to be done through a nearby school since the upgradation is still pending by the board for 9-10. So, my lord, that is the my lord. Today is yesterday was the last day, but the downtime was started by a notification of the state. It will be opening now.
You are appearing for the petitioner?
Yes, my lord.
File it. Leave I will not grant. File it will come on as per presentation form. If it is not taken up, mention. Yes.
If today will be the last day for this application through portal, and the nearby
For
school,
registration through that school.
And the headmistress of that school has agreed. But since there is in absence of
Last date fixed by
the state for registration, actually
state or the board.
Board was wait, 5th was the last date, but since the state has kept the portal inaccessible, it will open today. So it can presume that today will be the last day.
From where you are getting such presumption? You are forming such presumption.
No, there is a notification to that effect on 30th of June that for migration of portal, it will downtime will start along with this Bangla Shiksha portal. It will start from 1st of.
Well, board is the authority to make registration. So you file it, give the presentation form, and give the date in the presentation form. It is not taken up, then mention. Yes. Yes.
Mention one matter. It is appearing as item number 133 in today's list. Today, item number 129. Similar matters are going to be heard. This is the similar matter.
So let it remain in the list. Let me take up these first 9 matters. I have not allowed anybody's mentioning. If whatever order will be passed on these first 9 matters, that will govern the other matters. Yes, wait for some time. Yes.
To mention that 9610 of 2025, there was a direction to file affidavit of opposition within 4 weeks. They have not filed that because he was given to mention, madam. The 4-week sign was over, madam.
But at this point of time, I am not in a position to take up any hearing matter.
He was by the last.
Maybe, but the court is not taking up any hearing matter.
Madam, only short point, my lord.
Sorry. Yes.
To mention one matter. The petitioner dies on 2023, and till then the petitioner.
When you have filed the petition?
2025.
Then secondary or primary?
Secondary.
The matter must have come before me.
Yes, sir.
So then what was the order passed?
The order was passed to the learned counsel of the petitioner to submit a fresh copy to the respondent number 5.
Yes, I know what was the order passed. At that point of time, time must have been paid for. Yes.
Your Lordship, the petitioner here, Your Lordship, he was absent for he was supposed to retire in 6 months. That is the urgency. He could not attend school because he was prevented from joining school.
It is appearing in the list.
It is appearing 1066. The issue is, Your Lordship, this either Your Lordship will dismiss in limine or pass a direction for affidavits, given that he has been considered by an order of the concerned authority as dies non.
So he has not retired now.
He'll retire in 6 months.
Wait for some time.
Your Lordship, the issue is
sorry.
It has
Yes.
never been heard, Your Lordship.
No,
2023 matter, Your Lordship.
At present, yes.
1848, but this is gratuity matter, but it is in different.
Let it be called on, and then it will come under the different heading. Yes. Handover of which year?
2024.
Yes. Monthly list of August heading.
Let's say, may I permit to mention a matter for inclusion? The matter was not appear in the list. Your petition.
Which year motion?
2022.
2022, I don't have determination. At present, I have determination for some time, but it is not a permanent determination. So therefore, mention before the bench, regular bench, taking up 2022 matters. I have determination from 2023. Call the list. Sorry. No further mentioning. No further mentioning today. Call the list. Item number 1. I will take up first item number 9, which was heard yesterday, but the issue is same in all the matters.
No, item 9 issue is different from Mr. Bhattacharya.
Very well, Mr. Bhattacharya.
Mr. Bhattacharya has challenged the rules itself. Here, not the rule has been challenged.
In all matters, the rule has been challenged, Mr. Bandhavata.
No,
In 9 also rule has been challenged.
but they are asking for certain. Anyway,
The declaration for
I don't mind, my lord. If
Yes.
you not want to hear, I don't mind.
probably Mr. Mitra appeared. I heard this matter, but issue in all the matters is common. Issue is common. Yes. What is your case?
If the Lordship thinks that Mr. Mitra should be heard, I don't mind. He
No, no. All are to be heard.
Yes. Kindly turn to page 84.
Item 1, sir.
Sorry. Page 90, the advertisement.
কোন কেসটা করতে
1. No. ওটা 90 12
Page
90.
9 লিখছে বিকাশ স্যার 1 নম্বর
Yes, but I just meticulously placed the notification to show whether this is per se illegal. In terms of the judgment and order of the Honorable Supreme Court, therefore the source of notification is the Supreme Court order. Source of this notification is Supreme Court order. Read with order of 17th April in MA, so and so, has been directed to initiate fresh selection process to the post of assistant teachers class 9, 10, secondary and higher secondary, and to the post of assistant teachers 11, 12. The Commission and Government of West Bengal have already applied for review of the state judgment and order, and this exercise is strictly subject to outcome of the review petition and guidelines of the Honorable Court to be followed by the Commission. This notification is issued for conducting state level test for selection to
Mr. Bhattacharya, there is no confusion with regard to issuance of this notification in terms of the order dated 3rd April 2025, read with 17th April 2025. Now, this is the admitted position. Now, the situation is this, that if 3rd April and 17th April are to be heard, are to be considered together, in that event, there are certain directions given. You draw court's attention to that order.
Yes, I am coming. Yes, I am very happy. Now, kindly come to me, Lord. Page 91.
That is the order of 3rd April 2025.
This is the notification dated, my lord.
30th.
This is 30th of May.
30th May.
Page 1991 is the part of the notification. issued
Yes,
30th of May.
yes.
Now, kindly, my lord, note this. Eligible candidates.
Which part? Page 19?
By page 91, not 19.
91 clause 2.
2. Eligible candidates minimum qualification laid down in rules 225. Where do they get rule 2025 in connection with the Supreme Court order? First. Then
Eligible candidates with minimum qualification.
apart from the
No, minimum qualifications in rule 2025, which they have framed.
that the selection is being undertaken in terms of the Supreme Court judgment. The Supreme Court judgment says that 2016 selection should be done.
Where it is said by the Supreme Court.
Kindly come to me, Lord. The Supreme Court order at page 84, 85. But before that, now it's my duty to place before Lordship the division bench judgment of this court, which are before the Supreme Court.
Division bench judgment, Mr. Bhattacharya, come to paragraph 363.
Yes.
363, subparagraph 2. All appointments granted in the selection process.
Yes. Well, let us read, my lord, very carefully.
Yes.
363. তোমার বসে চুপ করে
363.
Yes, 363.
Roman 2. I.
All appointments granted in the selection process involve violators so and so are declared null and void.
Then straightway come to 9.
Yes.
11.
Yes.
11.
11.
Roman 11.
SSC shall undertake a fresh selection process in respect of the declared vacancies. These declared vacancies are not vacancies.
2016. 9, 10, 11, 12.
Involved in this 3 selection process, preferably within a fortnight from the date of declaration results of the ensuing elections. Then,
Then 13.
appointments for,
Then 13.
yes.
SSC shall follow the rules governing the selection process
in letter and spirit. Therefore, that rules which was prevailing with the division bench was not declaring this law, and that rule was challenged before the Supreme Court. Therefore, all things were that this is 2016 selection.
Where, Mr. Bhattacharya, it has been directed that new rule cannot be framed.
What the court says, that you initiate the selection process, the declared vacancies which were declared then, not new declaration, number one. And number two, shall follow.
Yes, the declared vacancies
governing the selection. Which selection?
Yes, rules governing the selection.
Selection.
SSC shall follow the rules governing the selection process in
Letter
two
and
letters.
spirit.
Whatever the rules are there, that
Yeah.
is to be followed.
Are there?
That is to be followed. That is to be followed in the next selection process. Now the vacancies. Now tell me, if there are 1600, say if there are 100 vacancies in 2016 selection process for classes 9, 10, 11 and 12. Now in the meantime, if due to creation of certain vacancies, if vacancies are added, this cannot be taken into consideration.
Can I just, if your lordships permit me, since your lordships have heard Mr. Mitra and your lordships have, if your lordship give me some time, I can clarify all these points.
I will hear you, Mr. Bandhu.
I understand.
I will hear you.
I will. These are the points I've already argued by Mr. Mitra.
No, but this was not a detailed argument.
I am not saying
you are not there.
Well, at this stage of motion, there cannot be any detailed argument. If your lordship thinks that detailed argument and matter is disposed of, I don't mind also. I don't mind also.
Allow me to hear, then
No,
I will hear.
I am
Yes,
saying,
I
I'm just saying.
I have that on basic prima facie issues. Therefore, this division bench judgment was declared at point of time, where the division bench says that.
So, according to you, Mr. Bhattacharya, first of all, the declared vacancies should be separated,
Yes.
and a selection process is to be initiated in terms of the recruitment rules of 2016.
Because these vacancies would arise because of the cancellation of appointment by the court. Therefore, the court permitted you to do it afresh.
Now, this order merged with the order passed by the Honorable Supreme Court. Let us come to that order.
Kindly come to order of the Supreme Court at page 83.
Paragraph 45 onwards.
Yes. Last question, got it.
Conclusion under
Yes.
the heading conclusion 45.
The last question relates to the relief, which it requires, whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who are appointed must be terminated, and they should be required to refund salaries payments. Since their appointments were the result of fraud, his amounts to cheating, therefore we see no justification to alter. Then 646. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void.
This is for a disabled candidate.
No.
46.
May I read it? Not specifically found to be tainted.
Yes, yes, yes. Yes, please read.
A selection process has been rightly declared null and void due to the egregious violations of the illegalities, which violates Article 16. As such, the appointments of those candidates are cancelled.
Yes.
However, the candidates who are all employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the entire examination process and results have been declared void. Then next week. 43 is not necessary.
Yes, it's not necessary.
Now, kindly come to 48.
48 is also
not necessary. The disabled candidates mentioned in this regard, which.
Yes, it is necessary. Please read 49.
Okay, I am reading 49. My juniors will not insist to read 48.
Yes, I am also saying it's necessary. Yes, please.
Lastly, we address the case of the disabled candidates. Our attention has been drawn to such cases where impugned judgment had held the appointee, so and so shall be allowed to continue on humanitarian grounds. While
paragraph 49 says.
No, I was in paragraph 48.
48. Yes, paragraph 48.
Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee, so and so, shall be allowed to continue on humanitarian grounds. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of their disability, these candidates will be permitted to continue and will receive wages until the fresh selection process and appointments are completed. Then, the disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation.
Not other concessions.
No,
Only age relaxation.
relaxation.
But in case of disabled, other concessions and age
But
relaxation.
we are not here troubling the court with disabled candidates. In our opinion, such a direction would be fair. It would allow these candidates to take part in fresh selection process, which should now be initiated to fill the vacancies. Therefore, this is now being
Now, where now I will ask you, Mr. Bhattacharya, where is the bar in framing separate rule?
First of all, I don't say that they have no power to frame rules, but that rules will come prospectively. Here, the declared.
No, in terms of the order of the Supreme Court.
Supreme Court always says, Supreme Court passes on at the point of time when the rules are prevalent.
Yes, but Supreme Court did not expressly debar the state authorities or the recruiting authorities from framing rules.
This question did not arise at all. My lord will have to consider that when court is passing an order, keeping the law as it was then available. And when court found that the appointments of a particular selection is bad, court is permitting to do that selection afresh. If you do that selection afresh, you have to go back to that situation. You cannot come back later and bring something new. That would be really betraying the confidence of the court with the authorities. Therefore, 2016 selection should be made in terms of 2000 selections.
That is your submission.
That's my submission. And then kindly come to me, Lord.
Yes.
Accordingly, paragraph 51, we uphold the impugned judgment cancelling en bloc entire selection process, but have made certain modifications in the direction issued by the High Court. The appeal at this was so and so. However, we independently take up the issue raised in filed by the state. That's a different issue. Now
come to 17th April order.
Now kindly come to Lord, the application filed by them before the Supreme Court.
And the 17th April order is German.
MA, kindly come to Lord, MA.
ওইখানেই তো আছে এই কেসটা দিয়ে আছে পেজ 86
হাতে কাছে রাখবে
আরে অর্ডার তো এইটা
Come to order dated 17th.
No, order will be necessary. Let us see what was the application made. Copy through that. এত কথা বল চুপ করে বসো তো application কথা শুনে kindly takes up the application.
Application that is miscellaneous application 709.
Yes.
Taken out by the West Bengal Board of Secondary Education.
What was the application for?
Page.
My lord will find that application on the next matter.
देखिए next matter টা দাও তো
রিপিটেডলি বললেন অ্যাপ্লিকেশনটা হাতে কাছে রাখো না ওইটা ওর থেকে দাও দিয়ে দাও একটু তৈরি থাকো না যেটা করতে বলি শোনো
page applications next matter.
Page running page 188.
Yes.
So this is the application. Also fine. This is the MA. They quote the order of the court. Then kindly come to paragraph 4. They have again quoted the order of the division bench. You kindly now come to paragraph 10. Pursuant thereto, a letter dated 22nd of April was sent by the Commissioner of School Education to all the district inspector schools in district informing them about the order dated 17th April. Thereafter, the letters dated 23rd April were sent by the DI to all schools in the district, sharing a list of the assistant teachers who were not found to be specifically tainted. It is submitted that the names of the applicants do not find place in the said list.
But this is referring to 17th April 2025, Mr. Bhattacharya. We are on the order date 17th April 2025.
Kindly explain, Mullah, I am misled by my juniors, unfortunately. Kindly takes up the application filed by the board.
This court is on 17th April 2025 order.
Yes, the 17th April order was passed
on an application.
I am not
But
just-
this cannot be
no,
that application.
No, I am extremely sorry.
Yes, yes.
I am extremely sorry. My lord, the application is at page কোথায়? Look, this application was filed by the copy দাও তো ওখানে? By the state. তোমরা ready থাকো না, এত কিছু করতে যায়। Lord, I just must read out Lord, the relevant portion. It is stated that, Lord, the page, paragraph 5 of the said application. Steps are being taken in terms of the judgment for filling of the vacancies which have arisen on account of the, well, I can note this, which have arisen on account of the selection process having been set aside. The applicant is informed that a letter dated so-and-so addressed by the state government to the West Bengal Central School Service Commission issued. By way of instant application, the appellant most humbly craves to seek appropriate directions and modifications of the judgment to permit the appointed candidates not found to be tainted to temporarily continue in the various schools without claiming an equity in their favor until the end of the academic year or until the process for fresh appointment is concluded, whichever is earlier, so that education of these schools does not suffer. That's the application. Now, my lord, I do not replace the other paragraphs, which is not relevant. Kindly see the what are the prayer made. Prayer was, permit the appointees not found to be tainted to continue in service till the end of the academic year or until the process of fresh appointments to such posts. Underline this, Lord. Appointment to such posts is concluded, which was earlier. On the basis thereof, the Honorable Supreme Court passes an order at page 86.
That is 17th April order.
Yes. We are inclined to accept the prayer made in the present application.
Just yes, 17th April. Yes, yes, yes.
We are inclined to accept the prayer made in the present application insofar as it relates to assistant teacher of classes 9, 10, so and so, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts, no addition, shall be published before 31st of May 2025. Then the examination and entire recruitment process shall be completed by 31st December. These are the two things, Lord. Supreme Court says, do it to those posts by 31st May and complete by 31st December. Until then, the non-tainted will continue and get decided.
I will permit you to read the rest of the
Yes.
orders. Now the problem is this: today, if court interferes with this selection process by making an observation or by setting aside this notification dated 30th May 2025, would it not lead to relaxation of time schedule fixed by this Supreme Court?
With deepest of respect, the court order, my lord, is not to be observed only to maintain the time schedule. The court order, my lord, has to be observed, and it is the duty of this court.
It is absolutely correct. It is under true letter and spirit. Now, but when with a default clause in 17th of April, this order was passed, then where is the scope left open to this court?
Yes.
To today, suppose hearing both sides, I set aside this notification dated 30th May 2025. Now that lead to relaxation of the time schedule or extension of time schedule by this court, that is according to this court is not open in view of the tenor of this court order dated 17th of April 2025.
But if your lordship finds that the first paragraph says advertisement for those posts is violated, will that be permitted? When the Honorable Court, Lord, is really thinking in terms that I have to...
That is troubling this court.
No, the court has to set aside. The Supreme Court judgments are there. Article 144 comes into operation. This will be duty of the High Court to ensure that the Supreme Court order is followed. Here, my lord, in the name of following the Supreme Court order and to avoid the wrath of the court, they have issued a notification. And if that notification seems to be apparently illegal, would the court, my lord, feel shy of not interfering? We want, let the time schedule as such be maintained, but you correct your notification. This can even be done by corrigendum. We want that this Supreme Court order, my lord, should be complied with.
Come to paragraph 3.
Yes. The state government, the applicant, West Bengal Board Education and the West Bengal Central Subdivision shall file their respective affidavits by 31st May, enclosing that with a copy of the advertisement for fresh recruitment, as well as the schedule therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published by 31st May and the affidavits are not filed, appropriate orders will be passed by this court, including imposition of cost. Now, to avoid this imposition, they have published a notification that 31st May. But is that the notification?
Now, what is the effect of the order passed by the Honorable Supreme Court dated 17th April 2025? That do this by this time, file an affidavit. So therefore, Supreme Court is still insisting of the matter.
So it's not insisting the matter. The Supreme Court dispose of the matter. Kindly it comes to us.
Then what was the purpose of calling for an affidavit disclosing initiation of the selection process by issuing this recruitment notification dated 30th May?
To ensure that this is done. Otherwise, the application could not be disposed of. Kindly see the last thing. The misapplication stands disposed of in the aforesaid terms. Court did not, my lord, keep any, my lord, control over the proceedings anymore. If it is to be done by my independent application. Now today, I was thinking aloud that if the Honorable Court
even Mr. Bhattacharya, even after disposal of the appeal by order dated by judgment dated 3rd April 2025, this miscellaneous application was entertained.
Was by the state.
Yes. So then where is the bar in approaching the Supreme Court for getting appropriate clarification?
We cannot approach.
But at the same time, the hand of this court is tied in view of the time schedule framed by the Supreme Court with a default clause, Mr. Bhattacharya.
My lord, kindly forget that the court is only bound to maintain the time schedule. Kindly think, court here sitting in the constitutional jurisdiction is my lord, also would be kind enough to consider
that a rule of law must be must prevail.
Supreme Court other directions. Supreme Court others directions in merit is not followed or not. Date is not only something which is directive.
But tell me whether this date extension of time can be relaxed.
I am not
because today we are in the mid of July.
Even then.
Now, if I set aside this notification dated 30th May 2025,
need not be set aside.
Then it will lead to extension of time for issuance of notification. Then today the resultant effect would be court has to give a direction upon the recruiting authorities and the state to frame a notification within fortnight or within 1 month. That will not lead to extension of time fixed by the Supreme Court.
Then the obligation would be upon the state and other parties that since this is the order due to, can you extend the time? But fundamental task could be.
So when you are approaching before this court, you approach the Supreme Court for extension of time.
Why should you? I have to first get a view that this is illegal. Supreme Court doesn't have the original jurisdiction to entertain a new notification. My lord is well aware that I cannot straight away go Article 32 petition filing a challenging notification. It would not be governed. Therefore, I have to approach the jurisdictional court, and if the jurisdictional court finds that this is illegal, then consequently I can approach the Supreme Court saying. Now, kindly, my lord, now since this is the order that here also on 13th of April, 17th of April, Supreme Court categorically states, you follow recruitment process to that post.
Advertisement for fresh recruitment.
Therefore, if those posts,
which paragraph? Clarify that all orders.
Now, will kindly come to me, lord. Advertisement for fresh recruitment to the aforesaid posts. Aforesaid post means, my lord, the 2016 selection. Therefore, if it is confined to 2016 procedure and law, there's no difficulty. Even today, they can issue a notification that this was a mistake. We will follow only 2016 rules and the vacancies.
And if aforesaid posts are clubbed along with the subsequent vacancies, Where is the bar in the order?
Because under the rules, recruitment rules, you have
And
to,
how this can be restricted to the candidates of 2016?
because they,
Because that will in contravention of Article 16.
not at all.
It's a public
Post,
employment.
well, the public employment for the vacancies declared. This is not a new process. But this arises because of intervention of the court. Well, had the court not declared the selection was over, then these new vacancies wouldn't have come. Can you consider this?
But nowhere division bench and Supreme Court has said, Mr. Nowhere, that this selection process is to be has to be conducted in terms of 2016 SLST rules of 2016, and it would be confined to the vacancies.
That I will then again.
Nowhere it has been
I will
observed.
again invite your lordship to read the judgment in its entirety. But what was the issue before the court? Can you excuse me without repetition? That 2000 selection is bad.
Yes.
Now court finds 2000 selection is bad. Now court says do it afresh to those posts. Therefore, the rights of the parties which were there accrued at 2016 would be considered. The subsequent rights would never be considered because these vacancies were near there in 2016. Categorically, High Court and Division Bench and Supreme Court says to those posts. Therefore, if it is confined to those posts, it will be confined to the persons who were then eligible. Otherwise, if 2016 election was not set aside, the subsequent vacancies, subsequent rules wouldn't have come into operation to tag with this. Couldn't have been. Therefore, reasonable and logical conclusion is that you have to hold afresh for 2016. Do it. We do not say that you cannot hold the examination.
So therefore, your sum and substance of your submission, Mr. Bhattacharya, is this first. These vacancies of 2016, 9, 10, 11, 12 are to be treated separately. And for filling up those posts, this separate selection process is to be conducted following 2016 rules.
That's the judgment, number one. And number two, kindly will again come back to the impugn notification. The notification is still inherently bad. And the Supreme Court, Milord, makes it very categorical that the tainted candidates would be barred.
Yes.
Prohibition.
That's true.
And you have allowed everybody to participate. Number one. Now, kindly consider the notice is inherently bad. Now, the kindly Milord.
Now, notification, I would ask Mr. Bandyopadhyay two things. First of all, where is the prohibition prohibiting the tainted candidates to participate? Right. There is no such prohibition. And another thing I would ask Mr. Bandyopadhyay to clarify that if you come to the mark provisions relating to allotment of marks.
I was going to say.
Now, they are
inherently bad. You are
that is also. আমার এই ইয়েটা কোথায় ওই লাস্ট ইয়েটা দাও তো ওখানে নোট করা আছে
Oh, you have come ready. That's good. The marks.
First of all, there is no express prohibition prohibiting the tainted candidates to participate. That you will, I know you will take this point. And the second is
distribution of marks. The additional marks for teachers comes. Thereby, you want to give benefit to those who have been declared null and void by the Supreme Court. Distribution of marks. But that will also get blood in the rules.
Yes, that is in the rule. It is there. Yes.
Schedule 2. At page 1110.
This prior teaching experience.
Yes.
whether 10 marks can be allotted, who has lost their job with a finding that there is egregious fraud. So how this can be reconciled?
And then again, if it is about the open recruitment for fresh recruitment.
10 marks for experience. Now, if a teacher who has rendered job in connection with 2016 SLST 9, 10, 11 and 12, how they will get
That
the
is,
marks?
you have correctly marked this. And then again, the distribution of marks was also changed.
That I have seen.
To create another door for corruption. I use this expression with all restraint. Now you have seen these rules. Kindly come to this notification which is under challenge is of dated 30th May. And
is there in the notification any provision that the tainted candidates should not be?
And this rule is published on 29th of May 2025. 29th May 2025 is the rule. And
30th May is the notification.
And there you say that we have additional vacancy in terms of 2025 rules. How could you arrive at the vacancy? If the rule was published on 29th of May and rule gives the detailed procedure for ascertainment of vacancies, how could you on the next day get the vacancies?
But I do not, Mr. Bhattacharya, find fault with clubbing of vacancies along with subsequent vacancies. If those vacancies are included, matter ends. But the question is, where is the embargo?
When the vacancy is included, you are
clamped upon the untainted candidate, tainted candidates.
Lord, that is one part you have already taken note of. When you are adding the new vacancies, you are inviting fresh candidates. Just a minute. Now that you see the classification is so irrational. When you say that I add these additional vacancies, then you are inviting the fresh candidates who would be eligible today, and they will be putting in competition with the 2016 candidates.
Yes,
is that fair? Apart from the question of distribution of marks, would that be fair? And when the Supreme Court and High Court says those vacancies only, because this is a fresh test of the persons who had participated. Today, they are thrown out. One group is completely banned, but another group is permitted that you participate and prove your worth. And if you now ask them to compete with the fresh students of 2025, that itself is illegal. That's why the rule says every year you have to assess the vacancies and publish the advertisement so that the fresh recruits can come and compete with the said vacancies. And clubbing of these two vacancies of 2016 and 2025 would be irrational and violate Article 14. You hold the examination separately for 2025. No problem. The fresh candidates will come and contest. Otherwise, you'll be putting us in difficulty, who are really the genuine candidates contesting 2016. Now, this notification, my lord, can even today be modified, corrected to respect the time schedule by the Supreme Court. 31st December, long way to go. Only this little modification that the portal is such that who have already crossed 40 years, they are not permitted to file, though the Supreme Court says age election should be given. The notification says the age relaxation as well as Supreme Court. If I am not allowed to enter, how would you assess whether I am age barred or not?
Yes.
Therefore, my lord, if your lordship, my lord, I just conclude, my lord, I will not take as prima facie case. The division bench judgment and the Supreme Court judgment, the court was always conscious of the fact that this 2016 should be done afresh. Nothing beyond that. Let them do it afresh. With the guideline, the Tainteds are out, and the age relaxation to the persons who had participated.
Yes, that is there in the order.
No, but portal does not permit me to enter.
Age relaxation, already there is a direction.
There is a direction, but not, I cannot apply. The portal says they were barred.
Overaged.
Therefore, the portal should also be, my lord, corrected. Now, beloved, I just cite one judgment, beloved, relating to Mayawati's case, where, beloved, the CBI initiated a criminal case saying that the Supreme Court directed. The court declared this is void. You cannot say this. When the court does not specifically direct, you cannot take the advantage of this. Take it out. These applications will not filed by the state or the West Bengal secondary education supported by the state. That will not be filed at case 249 in the matter of 12512.
Paragraph?
Yes, just. Now, this is 2012
8 SCC.
তোমাদের জন্য কাজ করা যায় না 2012 8 SCC Yes. The bylaw is final that in paragraph 14 stand of the CBI. That why did they do so? Now the Honorable Supreme Court will not really frowns upon them and says you cannot do this. Paragraph 40 and 41. And 43. Paragraph 44 conclusion says, in the light of the above discussion, we hold that in absence of any specific direction from this court, in the order dated 18 September 2003 or any subsequent
Paragraph
order,
40.
44 conclusion.
Just a minute.
Those paragraphs are given the discussions and for 44 is the conclusion.
Yes.
In the light of the above discussion, we hold that in the absence of any specific direction from this court.
Yes.
In the order dated 18 September or any subsequent order, CBI has exceeded its jurisdiction in lodging FIR number so and so. The impugned FIR is without jurisdiction, and any investigation pursuant that is illegal and liable to be quashed. Because even in case of criminal cases, Supreme Court has interfered. That you cannot take recourse of Supreme Court when the Supreme Court did not allow you or did not mention anything about lodging of FIR. Here also, when the Supreme Court is very categorical, they fill up those vacancies and remove the untainted candidates, give the age relaxation. All these three criteria have been violated. And that too notice in the name of Supreme Court. Can you not set it aside? Let me do it afresh. Or my suggestion before the court would be that these things can be corrected even today. That will not take much time. The correction can be done within 48 hours. The applications can be invited. The process, 31st December is the last date for holding examination. If any difficulty, let them say that we cannot do it by 31st December. We will remain approach the Supreme Court saying, kindly extend the time. Because we are interested to get job. But these are my points.
I'll hear you last.
No, last means.
I'll hear you last. Let Mr. Mitro.
Let me finish. I don't know. I have also other matters.
Because I have fixed matter after hearing you. After considering that you are available on this. So allow others to make submission in a short campus, and I don't think Mr. Mitro and Mr. Dhod will take much time.
Today it will not be finished. Today will not be matter will not be. After 12:30 I will not be available. Then in that case your lordship.
No, it will be concluded. Yes. Wait.
I have to accommodate. Then just a minute.
Yes, Mr.
Coming
Dhod.
for 2 minutes. Yes. Your lordship sleep. Just I am coming for 2 minutes.
The court has made some submission that has
Yes.
I'm not disputing the board's power to make regulation. Don't define. Only my dispute is such regulations cannot be in violation of order of Supreme Court. on those provisions in the regulation, in the notification, which are in violation or amount circumvention of order of Supreme Court, that will void, because that will be inroad into judicial power by civil authorities. That is on that principle. I am going to give those instances. That Supreme Court has consciously made a reasonable classification into tainted, untainted. Tainted, fraud, untainted, no question of fraud. So, Milord, Supreme Court allowed some advantages to untainted, which are not allowed to tainted, namely continuation service, till fresh election. And Milord, now question is, this Supreme Court allow Supreme Court allowed the first election for to be held? Participant will be whom? Who will be the participant? But kindly take the order of Supreme Court, paragraph 49.
এইগুলো সমস্ত সরিয়ে নাও তো।
The classification reasonable
Just a minute. Paragraph 49 of the order dated 3rd of April.
Just now, please.
3rd of April. Just.
In my petition house is annexed, but my lord have a same petition, same order. This, the only thing I.
Yes, paragraph 49.
49. Well, can you see below? The Supreme Court has treated tainted and untainted as unequals, not as equal. So the unequals cannot be treated equally by the board. That will violation Article 14. Which unequals are treated equally, that also violates Article 14. That's not perhaps a mistake they have made. Now, who are allowed to? I accept the argument of Mr. Bhattacharya that this fresh selection process to fill up the vacancies as declared in 2016. Accept. Kindly now come to paragraph 49. Who are allowed to participate in the fresh selection process to fill up those vacancies? Disabled candidates mentioned previous paragraph will be allowed to participate in the fresh selection process, comma, if required with age relaxation. Then similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxations. Only not tainted. Well, tainted are not being allowed by Supreme Court. Supreme Court allowed only two categories of persons to participate in the fresh selection process. One is disabled, section paragraph 48, and untainted. And even untainted will get the appropriate age relaxation, not others. In order
and also open category candidate, Mr. Mishra, also open category candidates. Those who did not participate in 2016. Why their right will be infringed?
That is, I'm not on that. They can make a separate rules. I'm not saying.
Yes.
Not disputing the rule be struck down.
Yes.
I'm saying only those provisions, and I point out those provisions, about 3 or 4 provisions, which do not tally with the Supreme Court direction. That is not. This is the Supreme Court allowed. There are two things. The vacancies which have occurred thereafter is different.
Yes.
But on the date of 2016 elections, there were declared vacancies.
Yes.
And this specific selection process is confined to that. Is vacancies as declared in 2016, which are now fallen vacant because of Supreme Court order of annulment. So, in the light of that, in my humble submission, it was appropriate for my lord to observe. Can you see my lord judgment? I'm reading out from the judgment.
Which order?
My lord.
Which judgment? Yes.
Yes. In the order dated 10th of June 2025, by this order judgment, and see the judgment. that specifically observed in terms of the judgment of Honorable Supreme Court dated 3rd April 2025, tainted candidates do not have the right to offer their candidature in fresh selection process. That Lordship, in fresh selection process, which was to fill up the vacancies. The additional vacancies, whatever the board do. If the board think it is proper or fair to give a prize to fraudulent candidates, they will do so. Let it go more. Because this is not, we have made a petition and to annex that at without that, and my petition, paragraph 8, copy it. And for my less convenience,
Yes.
copy it. Can we come to paragraph?
Unreported.
What is the case about? And we are very
Order date 10 June 2025. Give a copy to them.
Yes,
Which
yes.
part of the order you have just read? Internal page.
Interpret that request. It's good to me. Judgment is good. Judgment of judge can lead.
10 June 2025.
আরে একটা কপি এটা আমার ব্যাপার করো
আমি কাগজটা লিখছি না, ওটা করতে কোথায় যাবো?
প্যারাগ্রাফ নম্বরটা বার করে দাও তারপর Yes, you have got a copy.
Yes.
I learned it immediately. Down to page, there's no agitation. 1, 2.
Internal page of this order.
No marking in my copy. I have quoted in my notes. May I mark it? এই জায়গাটা mark করে দাও, যেখান থেকে quote করেছি।
আমি 10
No, paragraph normal name. My legend will go on.
This is in case of upper primary.
You know, you could read which page, last but one page. Last but one page.
Last but one page, yes.
Third page.
Yes, last but one page.
Second page from the beginning. Third page from the beginning.
Third page from the beginning.
Yes.
Yes.
Paragraph number.
First, second.
A middle paragraph. First, before considering the issue.
Third page from the beginning, third page. Now, which paragraph? First, second, or third?
Second last paragraph.
Second last paragraph.
First,
Another limb of submission.
Issue. First, it begins. First, before considering the issue raised in the writ petition, this court needs to find out whether the petition is untainted candidate or not, in connection with the selection process of first upgradation. Since, reason for this is, since, in terms of judgment of the Supreme Court dated 3rd April, tainted candidates have no right to offer their candidature in fresh selection process. That was the reason. And because I'm humbly supporting the judgment from paragraph 49 of Supreme Court that order.
Only two categories: disabled and not specifically tainted or untainted.
This is my support of my judgment. Let's come to this anyhow now.
Yes.
Is one thing.
Yes.
The reasonable classification made by Supreme Court
yes.
cannot be obliterated by board or anybody. No, anybody. Or the unequals cannot be treated as equals. That's valid. Discipline, my part. Second point is not number of vacancies in the post as directed in 2016 cannot be 2000 rules or 2016 to 25 seal process be reduced. The vacant posts which are declared in 2016, now that has to be filled up by fresh selection process. That cannot be reduced. which has been sought to be done in this case. This theatre. Heat. May I have, and with my nose kindly, below got the list made, and they have annexed a supplementary affidavit. If copies are wooden.
এখন আমি কি করবো এখন সাপ্লিমেন্টারি এফিডেভিট এত বড় what I will do with this supplementary affidavit at this stage now handing it. No, read means I am not very intelligent. I am a dull-headed man. I need time to read.
No, I'm trying to. I'm only relying on a list of.
Now, Mr. Mitro, as the last occasion, I also asked you.
Very good. But
that
in that case, your lordship is direct for filing an affidavit.
Last occasion, I also.
Lordship, can you give?
Last occasion, I also
so
asked
much
you.
arguments are there.
Asked you that in terms of the order dated 17th April 2025, that is.
I'm only seeking this direction from you, my lord. The posts which are vacant.
Come to the order dated 17th April.
17th April. That's the order of
Supreme Court.
The modification order.
Modification order. Same question I would like to ask you also.
Yes, please. Correct. Yes, sir. Thank you. Thank you very much.
Modification application 709 of 2025, order dated 17th of April, first. Yes. First paragraph, an advertisement for fresh recruitment to the aforesaid post shall be published before 31st of May 2025.
That has been done.
Then the examination and the entire recruitment process shall be completed by 31st December 2025.
Yes.
And more striking is the third paragraph, which is and fourth paragraph, that the state government and the applicant application, West Bengal Board of Secondary Education and the West Bengal shall file their respective affidavits by 31st of May 25, enclosing the copy of the advertisement for fresh recruitment as well as schedule, therefore, so as to ensure completion of the recruitment process.
Yes.
Then, in case the advertisement is not published by so and so, the default clause. So, in view of this, today, accepting what Mr. Bhattacharya and you have submitted, or other learned advocates representing the petitioners submits, if considering this, if this notification, recruitment notification dated 30th May 2025 is set aside, in that event, does it not lead to relaxation of time?
That's why without submit, I am not submitting for cancellation of either of the 25 rules or the notification. I am saying only those provisions therein which are in conflict with the order of Supreme Court, direct the board not to enforce those provisions. I have given one provision. I'm giving, my lord. Second provision, given that listen a minute. The order of our division bench was paragraph 363(11), which have been confirmed by Supreme Court. Page 93. You undertake fresh selection process in respect of declared vacancies.
Paragraph division bench order.
Division bench order, which has been confirmed by Supreme Court.
Yes.
Supreme has confirmed the order. Only time has been modified. Instead of 14, by given time. So we not only have this direction. And no question of any.
Supreme Court has modified with the time schedule.
Only time schedule.
Now, if this time schedule, whether it is open to this court to relax the time schedule.
No. Certainly, it's for Supreme Court relaxment. I'm not asked for any. That's why I'm not asking for order of cancellation or notification or cancel the initiation of selection process. I'm not asking for that. I'm saying this selection process we have started, all right, but that the posts which are declared vacant in 2026, they know.
That has to be taken into consideration.
That cannot be reduced by abolition of anything else. That is the only direction. Can you make that direction? That will not affect the selection process. Allowing or disallowing
And the two categories of,
363.
only two categories of candidates are to be permitted to participate.
Yes, number one, direction. Number two, the vacancies were declared in 216 election process. Those posts cannot be abolished or reduced. If they are hard posts, that's post. And I've given example of such posts in a list, which board knows, etc. I've given in my notes also. I have mentioned that illustrative text and explanation is given.
Yes.
This is second direction. Third direction, I'm asking from your lordship upon the board that any age qualification of candidates for selection of 2016 as per 2016 notification and rules can be relaxed only in respect of untainted successful candidates. If Supreme Court says, my lord, should be allowed age relaxation in paragraph 49 to only two disabled candidates and tainted candidates. Untainted candidates. So now this age qualification cannot be relaxed in respect of tainted candidates if they appear or any other candidate. If they appear
Yes,
for
yes. Question of participation of tainted candidates in view of the observation and directions contained in the order dated 3rd April 2025 does not arise. That is
one thing.
That is clear.
And there may be other candidates who had not at all appeared in 2016 selection process, but new candidates may come in. But don't allow age relaxation to them. So far as the specified declared vacancy of 2016, I'll make it clear. Declared vacancy to 216 vacancies are concerned. For filling up those vacancies, board cannot change the age qualification as given in 2016 selection rules, namely minimum 20 years, maximum 20 years, as on January 2016, which board is now purporting to make minimum copy it.
Yes, Mr. Mittu.
It has been now. Yes.
So
which
the
have been-
vacancies which are earmarked for 2016 selection process
As
cannot
on.
be open to other category
cannot.
candidates. Yes.
So it must be minimum age 20 as in
This is
January
subject to your
2016.
signature. Yes.
16. That board cannot now make that minimum 20 or maximum 40.
That is also on this point, Mr. Bhattacharya also argued
Yes.
that these vacancies are to be kept separate for
Yes,
2016.
that's applied.
So I have lost the-
Now what they're doing, my lord, they're making the age qualification minimum 20 and maximum 40 as on January 2025. That giving 9 years age relaxation. And that the new selection, but that should not be given. Now become 9 years age relaxation, minimum qualification 20, 20 and 40 was as on 2016 January. Now they are making it as on January 2025. That is in violation of order of Supreme Court.
But Supreme Court directed to give age relaxation.
My lord, that in respect of declared vacancies, that age qualification cannot be relaxed. If the other vacancies are there, let them fill it up in the proper as per rules. I'm not saying rules is altered is what, only pointing out some provisions which are in circumvention order of Supreme Court. That is document. In other words, I am pointing out only one, the clause page 1. No, page 1. Doctor have taken my petition.
Yes.
My petition, page 144 of my petition. Doctor get that educational qualification, including the age limit.
Yes, page 144.
This one. This is age limit of to find minimum 21 years and maximum 40 years as on 1st January of the year of publication of advertisement, that is 2025. That publication advertisement 31st May 2025.
So, but minimum 21 and maximum 40 is the normal procedure for that is the normal age.
Correct.
That remains.
That-
But what
that-
is the age relaxation given to the untainted candidates?
My only submission is because now Supreme Court is fill up the declared vacancy of 2016, and in so far as for direction was filling up the vacancy of 2016, the age qualification should be as on 20 and 40 as on 2016 1st January, and not 21st January, 20 January, 1st
For
January
the candidates of 2016.
2025.
That is your plan.
Yes, only I'm only concerned declared vacancy.
Yes.
And not in my petition, I should get that copy of the previous, what was that age and what. No, my lord.
So age to be considered with effect from 1st of January 2016. Yes.
And the last direction I'm asking, last direction.
Yes.
Now Supreme Court has said.
One thing I just want, Mr. Mittal, let Mr. Mittal submit whether he is asking for that is total, this notification should be.
No, I'm not asking for.
Ultra virus or not?
No, I'm not.
No, please. Prayer A is that. Prayer A is that. Let him record that, that's whether he is pressing for it or not.
No, let's record it. I'm not.
Prayer
B, actually. Prayer B, I'm not.
Let him
Right.
pray first, this prayer B, he is not.
I'm saying,
pressing.
okay, let's record that.
Then one of the party is not pressing prayer B.
Yes, correct.
Then other alternative prayer comes.
That's
Very
right.
good.
I'm already submitted.
No.
Yes, can you record?
In the morning said that Mr. Mitra has also sought for.
Yes,
Dictation.
yes, very good.
That is the ultra virus.
That is there in the prayer.
Can you record? Can you record prayer B? I'm not pressing for. I'm asking for. The last direction I'm asking for, last direction upon the board is that Supreme Court direction is very clear that untainted candidates will be entitled, eligible to participate in the fresh selection process for filling up the vacancies of 2016. Correct? No qualification is necessary for that. Now, what the board has given a direction, the marks, the qualification marks in under 260 regulation was 50 marks in academic. And in the 2016 election, the qualification marks was 45%. By getting 45% marks in academic, there have been many candidates who are allowed to participate in 2016 election process and be successful in that also.
So therefore, you are also questioning this fixation of minimum qualification 50%.
Minimum qualification.
Yes, yes.
So in so far as filling up
have been 45%.
Vacancies of 2016. I have prepared a humble note.
Yes, you have submitted this note.
Yes. That is not an that's okay.
If anybody wants to add anything,
I'm not
yes, don't take much time.
There is.
Wait. Yes. Yes, I'll give you. Yes, I'll give you.
Absolute zero.
I will give you, Mr. Bandyopadhyay.
That was a part matter. I requested you to put that tally.
I'll give you. Anything you want to add? Yes.
My path would be a middle path. I would not
May I
be
make
making
minus kindly?
assumptions of either of the extremes.
That I'm making clear.
What
I'm
I'm
not.
saying is this. Well, usually in statute we have a clause and a super clause which can override others, which is not available in case of a judgment of the Supreme Court. So therefore, harmonization is required to be done by your lordships if situation arises.
But where is that
So I'm
scope left open?
I'm coming.
In view of the time schedule.
I'm coming. So therefore, I am not saying
one thing. It is directions which I am asking. Only the report directions. If that is a if direction is given, and with a board thing because of direction,
yes,
it is not possible to complete within.
No, we are not thinking, we are supporting, we are not.
Then,
We are not thinking that.
then we
are
can
fully
we
supporting
can
this.
jointly apply.
Not-
Then
Get the order, get the
so
order.
I
That's
bless will
We are
understand
not thinking.
that these directions will not
No,
will
no.
not
We are
require
not thinking.
will not
There is
require
no-
extension of
there is
time.
no use of wasting time on that point. We are not thinking. We are supporting it and we want to see that the
Yes.
selection is done in terms of
Yes.
this. Finish.
Those direction will not
Unless
this,
my lord declares that this is a ultra-virus, that's a
no,
different.
no, I'm not saying.
No, that's a different thing. Others will proceed on the basis.
Yeah.
of this. We are not thinking at all in a
No,
different way.
This post direction will not call for extension of time. That's
No,
different.
no.
Well, I
Okay.
was,
Then may I take it?
I was trying to harmonize, and I do agree with lordships.
And
Prima
also
facie,
I want to point out to your lordship, there is another article and content petition pending with this. Let me inform you, but nothing more than that. That doesn't mean that I will not argue.
yes.
but I would begin with,
Supreme Court may say no, we are not in go to High Court.
and I would begin with,
Or
I completely think that that would be the first and prima facie, my lord, the opinion that Supreme Court in season of the matter. Absolutely, because that's the expression. I understand that. Now there are two things. One is this notification is good or bad, set aside or keep it as if it is absolutely perfect. This is one. Other is there are some irreversible situations, like in the notifications, the last date of form fill up is 14th. There are number of situations where because of the last date being 14th, many of them, they are disqualified. They were qualified under 16. Some posts where they are now found to be not there. So they will not even able to participate. All I shall be praying today and an interim order without affecting any of the Honorable Supreme Courts. Now there is a vacation. Supreme Court, Honorable Supreme Court will be reopening on 14th. I would be only seeking, because I don't want your lordships to enter into the entirety of the matter, because it will cause lot of time, lot of intricacy of laws, and I cannot make a very biased interpretation. Both sides have their things to say. But till that time, kindly extend the form fill up. Supreme Court has got said nothing on that. Kindly come to the MA order. Paragraph 3.
17th April.
Yes, 17th April. Because if 17th April stops your lordships and lordships cannot.
Just two. Yes.
Kindly see paragraph 3. Before that too, the examination and the entire recruitment process shall be completed by 31st December 25. This cannot be tweaked by your lordships. It is watertight. Cannot be. 3. State government, the appellant, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 25. Cannot be tweaked. Enclosing therewith a copy of the advertisement for the fresh recruitment, cannot be tweaked, as well as the schedule, therefore, so as to, kindly mark this, ensure completion of the recruitment process. This also cannot be tweaked. Now, 4. In case the advertisement is not published by 31st May 25, cannot be tweaked. And the affidavits, kindly look at it. And the affidavits, so it's a document itself, not about,
Are not filed by that date, the appropriate order will be
exactly.
passed.
So therefore, lordships cannot,
For according to you, 31st of May cannot be relaxed.
Yes.
31st December cannot be
Cannot be.
relaxed. But a date can be relaxed.
all I'm
But there's a
praying,
problem.
I'm saying, all I'm praying that there are multiple problems which are fundamental in character. all I'm praying, kindly extend the date of form fill up by 1 month.
If I extend the date of form fill up from 14th July
Yes.
to 14th of August,
Yes.
in that event,
Yes.
it's a huge process,
No.
Mr.
Kindly
Dhar.
see the
That
irreversible
from
effect.
14th of August to 31st of May, 31st of December 2025,
Yes.
it may not be possible for the commission to complete
Right,
the recruitment process.
But there comes the clause and the super clause. I say that Lordship is seeing these directions of the Honorable Supreme Court as super
So court
clause.
needs to proceed taking into mind that the Supreme Court has fixed from 15th of July to 31st of December 2025 being the date
Yes.
by which School Service Commission has to complete the selection process.
Correct.
If that court accepts,
Yes.
then it is not open to this court to extend the time for filing for submitting the forms.
My Lordship has ample power. The reason is this. This is one part of the Honorable Supreme Court order. There are other parts of the Honorable Supreme Court order which entitles me to participate. Now, large number of participants.
Any other submission, Mr. Dhar?
The irreversible effect is this. Kindly have a look at the irreversible effect. That my supplementary 1 page, page 17. This post is not even there. I've given the list.
Yes.
45%. Earlier it was the eligibility. Now it has become 50%. I won't be able to. So all I'm trying to say, there are other part of the Honorable Supreme Court judgment that has to be adhered to. There are this part of the MA order that is also to be adhered to. This now, while adhering to the time, can the other contents of the Honorable Supreme Courts by which I was entitled to participate, can that be taken away? I said, Lordship, do not answer finally. But kindly look at the liberal view and the narrow view. The liberal view would be if Lordship extends that, nobody dies in the meantime, when the matter is decided. Because otherwise, 14th is last date. None of them would be able to participate. So no matter what.
Any other?
This is and as far as the contempt jurisdiction, my lord, that is a completely different purpose. Because there is a judgment of Parihar, paragraph 6.
But I have given different 3 judgments. I have referred to in my note for the well-known proposition that legislator cannot make inroad into judicial power without taking away the basis of the order. For that, I will not reference similar
This
3
is the
judgments.
paragraph.
I've given the reference to my last.
Paragraph 6.
Yeah, 1970 Supreme Court 1292, then 1974 Supreme Court 1232, and 1995 6 SCC page.
What is the proposition? What is the proposition?
In a note I have mentioned in paragraph 5 below. So it's unfair on my part not to apply.
So you tell me the proposition.
Yes. Paragraph 5 I have noted. AIR 1970.
No, what is the proposition of law based on which you are citing this judgment?
On the question that this any order or subordinate legislation which is in violation of order of court is ultra vires constitution because taking inroad into judicial power without removing the basis of the judgment. Paragraph 5 also find that. And not I'm giving my hand. And take it, no. I hand paragraph 5. Last paragraph. Last page.
Yes.
And I have handed back my notes of submission to my learned friend, Mr. Bandyopadhyay, for his concern. So everything I'm putting on the table.
This is the judgment 96.
No hide and seek.
This is the judgment of J.S. Parihar.
Yes.
96, 291. Clearly saying, if I can read 2 sentences, The question is whether seniority list is open to review in the contempt proceedings to find out whether it is in conformity with the directions issued by the earlier benches. It is seen that once there is an order passed by the government on the basis of the directions issued by the court, there arises a fresh cause of actions to seek redressal in an appropriate forum. The preparation of the paragraph 6 placitum, my lord, around G.
Yes.
And I say that,
Yes, Mr. Bond.
I say that there is a requirement of the new
Anything you want to add?
Kindly just
complete
let
this
them add
sentence.
it, my lord, after my just kindly.
Just
My lord,
one
I
sentence,
thought
my
it
lord,
that
just
one item against I will argue. One item I will, then the one first Mr. Vikas Bhattacharya, I have to argue. Then two, somebody will take point. I have to argue.
You have to finish with one sentence. There is a requirement of the new rule because the SSC is required to change the waymark, which is the cause. Now they have made it preservation rules. There are several rules which were the reasons for quote and unquote corruptions.
Very
So
good.
therefore, I do think there is a need of a change. No doubt about
All
it.
these lawyers have appeared on behalf for the corrupted peoples before the on another bench.
I think allow
Now,
me to say, Mr. Your turn will come.
uh-huh.
So therefore, I say there is a need.
You are arguing in my
Yes,
turn.
he will complete, Mr. Bondora. Please take your seat.
You are arguing in
That
my
there is
turn.
a need because otherwise old rule which was found to be incorrect, destroy the OMR, that had to be changed. I also feel number of increasing vacancy, administrative matter, nothing wrong about that.
Yes, that
Nothing
is
wrong.
also the view of this
There's
court.
nothing wrong about that. And I feel that
But those vacancies must be clubbed.
those vacancies can be clubbed, there is no difficulty. But all persons who are eligible to participate in 16, they should not be barred.
Excepting tainted.
Excepting tainted. Now, tainted, my lord, I read and found possible two views. Two views are possible. Though I am going to say tainted should not be allowed. That's my view. I'll try to support that. But that would require a lot of time ultimately to come to a conclusions. So might be Honorable Supreme Court. But till that time, my honestly request before Lordships, kindly ensure that no irreversible effect happens. So if the form fill up, which has not been touched by the Honorable Supreme Court, if that time by 1 month is extended.
That you have submitted, Mr. Yes.
My lord, kindly, otherwise, my lord, I will not be able to. Kindly, some kindness to kindly show to me, my lord. Some kindness kindly show to me, my lord.
I will hear you.
Lord, I have other matter. I thought it item 1, your lordships will give me the answer.
Give importance to this matter.
No,
Mr.
that,
Bondwat,
it's all right.
You know the
I am not
outcome of this matter.
I am
You know
not.
very well.
I.
So therefore, the lawyer.
I am not saying so.
Should give some importance.
Absolutely correct. But so far item 1, when it is happened, then item 1 I will
Let
give
your
the answer.
junior argue in that matter. I will hear you in this matter. Yes. Please take your seat.
Very nice.
Accepting Mr. Bhattacharya's submission from paragraph 7 onwards.
11 matters have come together.
There was a time fixed by the Honorable Supreme Court. Here, for the judgment of your lordship. This is your lordship's judgment. Paragraph 7 onwards. Your Honorable Supreme Court fixed the time limit. No, that's not this another matter. In parliament.
That primary matter.
Exactly.
In IOS.
That they should be allowed if situation arises, parties will be at liberty to approach the Honorable Supreme Court for extension of time.
Yes.
So extension of time is not a matter. The second submissions I tell your losses. So for the main judgment your losses, that substantially defines and concludes the right of the parties. And the last order, you'll must only the procedural.
But in that judgment, I have not extended the
now
time.
I tell your losses. What happens? Because of new rules.
That is a situation where court has held that in IOS we delete a similarly circumstanced candidate, but they are not the appellants before the Honorable Supreme Court. So therefore, they are to be considered separately by submitting their credentials, their eligibility to be considered.
The time limit was that only the appellant to be appointed by 31st.
That was in connection with the appellants only.
That's your lawsuit. That's why I could not complete with that. Here the situation arises
so far 2016, 19, 11, 12, there is no division. Only the all the candidates case are before this court. Now Supreme Court has specifically said that by 31st May you have to initiate
Complete the
proceedings.
appointments of appeals.
And by 31st of December, you have to complete the process, 31st of December 2025. Now, if this is the specific direction of the Supreme Court with a default clause directing the authorities to file an affidavit disclosing the recruitment notification, failing which an appropriate order should
They have issued the
be passed.
recruitment
This
notification.
has a different ramification, Mr. Shannan.
According to me, it's not that. If there is any default clause of the Supreme Court order, if ultimately found by your lordships that this is a violative of the rules and the Supreme Court order, they have to go before the Supreme Court and say, because of this, you extend the time. This is the court of the order of the Constitutional Court.
So that
was the same
that
situation.
you
in the
also
earlier.
approach the Supreme Court praying
But
for
they will approach your lordships in our matter directed. The board will approach for extension of time if the consideration cannot be made.
Very well.
Second, your lordships, both the petitioners in item number 8.
Yes.
Now, both the petitioners are in earlier round of selection process were selected. They were serving. One in English, one in political science. Now, because of the new advertisement, they are not entitled to be appointed.
45%, 50%.
This is one point. Now, your lordships kindly consider this judgment of our High Court. This is reported. Neil Madhav Das and others versus State of West Bengal and others. Your losses might remember this situation, where two selection process was clubbed together, 2005 and 6, by an advertisement in 2009.
Yes.
This High Court interfered with the situation. Your losses kindly consider page 2005, page 5. Kindly see, these are the points: controversy, number of vacancies different, year of vacancies different, category of vacancies different, date for calculation of qualifying age are different. Now your losses will find next your lordships page 11 why the single bench orders were affirmed that two vacancies cannot be clubbed together. Page 11, the second paragraph and third paragraph. Third paragraph, fourth paragraph. The qualifying age in respect of recruitment.
Third paragraph and fourth paragraph.
Yes, without number.
Yes.
The qualifying age in respect of recruitment process initiated pursuant to the requisition dated 2005 was different from subsequent recruitment process 2006. And then in the aforesaid section, the candidates in respect of 2005 recruitment are separate in every respect from the candidates sponsored by the subsequent requisition. The advertisement means they will re-advertise the vacancies already declared. They cannot include the subsequent vacancies. They are governed by the subsequent rules entirely. These are my answers.
That is the submission of Mr. Bhattacharya.
Exactly, your Lordship.
So the separate posts are to be considered.
অনেক সময় একটু অনেক করেছে একটু বস এটা আমাকে একটু শুনতে আরে 2 মিনিট এখন একটু
Yes, Mr. Bandopadhyay.
হ্যাঁ
Yes, you start.
মানে kindly see I just tell you lordship ভাই এবারে now my turn মানে kindly see you will give the answer you will
I will hear you later. Yes.
মানে kindly just I take your lordship from the very basic thing. Let us tell your lordship the facts. There was a selection in 2016. In selection there is a panel.
You are representing whom?
I'm a SSC. Panel is prepared. Who are unsuccessful? Those whose names are not in the panel. Correct? In the panel, those names were their panel. High Court directed to make a CBI inquiry. Right? From there, tainted, untainted categorization have come. These dual disqualified persons, in their cases, it has not been done.
Yes,
these disqualified persons, whether tainted or whether untainted, nobody knows. What has happened? Ultimately, entire selection process is gone. Their selection process is gone also. Those who are selected, their selection process have gone also. Therefore, all selection process has gone. What the Supreme Court has done, all appointments are set aside. First order. I'm coming later. All appointments are set aside. Whether tainted would remain or untainted, all appointments are set aside. What is the consequence? Nobody in the employment from the selection. Selection process is illegal. Whether unqualified or qualified. Their cases are not scrutinized, here cases have been scrutinized. Selection process itself is set aside as tainted. Selection process has been set aside as faulty. No right to them, no right to others. On the date of the Milord, first date of the judgment, that is that is the page. 3rd April, Supreme Court judgment. Let me read the judgment. That will give. Milord, kindly see the 3rd April judgment. What page? আমার এখানে দাগ দেয়া আছে দিন না। Kindly come to paragraph 1st, 75. Milord, it has been set aside, etc. It has been shown to you, Lord, so I don't need to require to show. All have been set aside. Now, your lordships, kindly come to 1st paragraph 70. আরে ভাই তুমি দাঁড়াও না ভাই, তোদের এক দোষ হয়েছে, ওখানে হচ্ছে শামীম আর এখানে হচ্ছে তুই।
Yes, Mr. Bandyopadhyay.
Kindly come to Milord, page 1st, 46.
Paragraph 46.
Yes. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violates Article 14 and 16 of the Constitution. As such, the appointment in these candidates are cancelled, all cancelled. Selection process is gone. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the examination process and results have been declared void. This is the order. No candidates can be appointed on the basis of that selection. Whether it's unsuccessful, whether tainted, whether untainted, no one can be appointed from that selection process. Not future selection process. Not future selection process. From that selection process.
How you are submitting this? Come to paragraph.
I just give me time. Give me time.
Because we have to consider it in the light of the order.
I am coming, sir. I am coming. Just give me time, sir. Kindly. Give me time.
We cannot attribute our own interpretation.
No. I am saying, I have my submission.
Yes.
I have my interpretation. Your lordship may accept or may not accept.
Court can ask Mr. Bandyopadhyay.
Yes.
For SSC that if this submission is found to be in teeth with the order of the Supreme Court.
Absolutely. I am coming. I am making first this judgment's first interpretation. I am saying on that date, I have started with the submission on that date of the judgment has been delivered. Therefore, on that date, everybody should go.
Yes.
And that I am submitting. Possibly I was not clear to your lordships. On that date, now kindly come 47. Type to 47 paragraph. Come to 47. Some of the appointed candidates who do not fall within the category of the tainted candidates, kindly see, may have previously worked in different departments of the state government or with autonomous bodies, etc.
That is not relevant.
In such case, all their appointments are cancelled. See, cancelled. But the candidates will have the right to apply to the previous department or autonomous body online in service because their continuity in service. Paragraph 47 is specifically for
some of the appointed candidates who do not fall within the category of tainted.
Correct. Those who are working in other department, they will go there.
Repatriation was
even
necessary by creating
supernumerary, and their continuity service has not been disturbed,
interfered with. Right. But that is confined to tainted candidates.
They're untainted. I am saying that is an untainted. This benefit has been given by the Supreme Court. Then kindly come to Milord, paragraph 49. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concession. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation. Kindly read this line. Only for the untainted candidates there would be age relaxation. But untainted candidates will not be appointed. That's not there. Tainted. So for the untainted candidates, age relaxation will be there. Age relaxation will not be for any other candidates excepting the untainted candidates. This sentence doesn't mean that tainted candidates cannot make application without any age relaxation, or this had not been made for the candidates which application can be made, even the who are unsuccessful, where selection process has been set aside. Kindly read this.
Similarly, other candidates who are not specifically
In our similarly, other candidates
who are
who
not
are not
specifically
specifically
will
tainted
also be eligible
eligible
to
participate with appropriate age relaxation.
Yes.
Participate
excluding tainted candidates.
No. No, my lord. No.
Yes.
But this is our.
That cannot be a clarification.
My lord, that is.
That clarification I didn't expect from Mr. Bandyopadhyay.
No. This is my
Yes.
clarification.
Yes.
This is clarification.
Yes, Mr. Bandyopadhyay. I am eager to get an explanation from you.
No.
Which is.
My lord, your lordships may not accept but don't be annoyed.
No, I am not annoyed.
Don't be
I am
annoyed.
Also expressing my mind.
No.
So that you can respond.
Yes, all right, but not with annoyance.
No, not at all.
Not at that.
But I am also seeing your annoyance not being permitted to make an argument within time. From
not being permitted to do.
Yes, you are saying that from 12:30 I have other matters. Allow others to.
Why you are mixing up all these issues? Then you could have taken it. I am stopping it
because accepting your submission and your request, I fix the matter today.
Correct. I am not saying so, but I expected also item 1 is finished. Item 1 I will argue. But if your losses will
all the matters if separately matters are to
no
also appreciate the
this is
court,
my lord, I am not come here to quarrel with your lords. I have not come up to quarrel with you.
No, why should
I am not come. I am not. No. My lord, I am a very small lawyer. Why should I quarrel with a great judge of Calcutta High Court?
That knows everybody that you are a very small lawyer.
Yes,
but
I am very small.
That
great judge can that's all right.
Query.
Yeah, of course, I am giving an answer.
Any senior advocate.
But I am
the beauty of our constitution. Now the thing is this, Mr. Bandyopadhyay, paragraph 49. Your submission is this.
Beauty of our constitution is beauty of our is this. If the judge does not accept the submission of a senior lawyer, then judge would become annoyed. This is not beauty.
No, I am not at all annoyed. This is a way this court generally responds. Yes. And at the same time, court also expects that there is no annoyance from from a senior advocate like Mr. Bandyopadhyay.
Why should I?
Because others are looking at you, they are learning from you.
No, I will not argue better.
Yes, please proceed. Please
proceed. No.
Yes.
No, I will not argue.
Please proceed.
Your lordship is making very caustic remarks.
Yes,
Mr. Never anybody has made such a caustic remark.
Mr.
No, I will not argue. You are a great judge. I will not.
Court is eager to hear it.
No. You are so. I don't know. Days are changed.
Yes.
That much I can say. Days are changed.
So therefore,
my lord, kindly see.
Yes.
My argument is this will also eligible to participate with appropriate age relaxation.
Therefore, your argument is this in a short campus with regard to paragraph 49 is this. Those who are tainted, they will not get age relaxation. Those who are not tainted, those who are untainted, they will get the benefit of age
relaxation.
That is
my argument. That is my argument. And whole rule is based on this. It's an open category. Open category. Now, as it would above these candidates to
just a minute.
No, post now. Now, if you restrict it,
yes,
my lord, kindly see, if your lordship restrict it, just for an another view I am giving, if your lordship, then only untainted candidates can apply. Neither tainted nor the unsuccessful candidates.
couldn't follow. Yes, please repeat it again.
Let's assume that your lordships, if your lordship says only untainted candidates will apply, then in that case, my submission, interpretation has to be given. Neither the tainted candidates can apply, nor unsuccessful candidates can apply, though otherwise eligible. Kindly appreciate this. That is the reason I have started with this. See, the inquiry was only for the panel candidate. Inquiry was not there for the unsuccessful candidates. We do not know who are tainted or who are untainted amongst them.
But is it required to enter into the this issue after the order passed by the Supreme Court,
After
specifically prohibiting tainted candidates to participate?
Lord, I am submitting. Here is no prohibition of any other person. No person is prohibited to make an application. Lord, this is my submission.
Now, your submission is that untainted as well as unsuccessful in 2016 selection process will not be permitted.
No.
If that is accepted.
If this interpretation is accepted, that only the untainted candidates would be given the chance with age relaxation, then tainted and unsuccessful candidates are also barred.
Why unsuccessful candidates?
Why not?
Clubbed with with tainted?
Why not? Did we make any inquiry whether they were tainted or untainted? Inquiry was tainted or untainted. They were unsuccessful. Nobody, kindly see, my lord, just excuse me. At any point of time, unsuccessful candidates' fate was not discussed because they are not entitled to. If an interpretation is made, I am submitting, my lord, I am submitting that this with appropriate age relaxation means only in the case of untainted appropriate age relaxation. But it is open to all. But it is open to all. But it is, if it is interpreted that only the untainted candidate can make application of that selection process, then accepting untainted, neither tainted nor unsuccessful candidates can make an application.
Only simple question I am asking.
My lord, I will try to give answer.
In view of the order passed by the Honorable Supreme Court.
Oh, yes.
Or judgment of the Supreme Court dated 3rd April 2025.
Yes.
Read with the order passed on an application dated 17th April 2025. Whether tainted candidates should be permitted to participate in the selection process.
This is your question. Yes. I am giving you answer. Come. This is the only question. Nothing more than that. Now, what has happened? All termination. Effect of 3rd July order is a termination. 3rd July, no?
Yes, yes.
3rd April. Sorry.
3rd April.
3rd April, all termination. Tainted, untainted, all termination. Now, from April, there are vacancies. This untainted were not going on in the employment. Then who made an application? Board made an application. Not the state, not the SSC. What they have said, kindly allow us to conclude to make the interview complete. Until that, kindly allow us to continue with this. For which classes? They have made an elaborate application. Now, what the Supreme Court said? Kindly come to page 86 first.
Paragraph?
Page 86 is the order. Let me read this.
No, tell me the paragraph because I am...
No, kindly from the top.
Order dated?
The order dated, my lord, that order what your lordship was referring to? 17th April.
17th April. Just. Yes, 17th April.
We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10, classes 9 and 12, not found to be tainted, subject to the following condition. We are ready to accept. Prayer for what? Prayer for continuation of their service until the selection process is made. That was a prayer by the board. Now kindly read again. Kindly excuse me. Sorry, my lord.
Yes, yes.
তোমরা এরকম করো কেন বলো তো? We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10 and class 11 and 12 not found to be tainted subject to the following condition.
That is according to you, is this with relation to their continuation
of service, not for any other
it has
reason.
been extended till 31st of December.
Correct.
Yes.
Those who are untainted, let us kindly see group CD they have not given. Group CB also tainted
To
and
that extent, there is an observation in this.
that's right. Group CB did not only for 9 and 10 and 11 and 12 continue with this service. That doesn't mean no, they will continue with this service till doomsday. No, they have to come through a selection process if they continue up to 31st December.
But subsequent directions?
I am coming, Milan. Therefore, this is only for continuation of appointment, not for any other factors. Next, an advertisement for fresh recruitment to the aforesaid post. Post means 9 and 12. We have not done other, only 9 and 12.
9 to 12, yes.
Shall 9, 10, 11, 12. Subject shall be published before 31st May. We have done it. The examination and the entire recruitment process shall be completed by 31st December 2025. The state government, the appellant, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 2025. Enclosing therewith a copy of the advertisement for the fresh recruitment as well as the schedule. Therefore, as so as to ensure completion of the recruitment process by 31st December 2025. In case the advertisement is not published and the affidavits are not filed by the court, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. Therefore, what are the risks were there? Risks were first risk to us, I mean to the board, that their employment will be terminated if 31st May 2025 is not done.
Whose employment will be terminated?
Those who have got this by this order
31st of December.
Up to 31st December. Their service will go. Second risk, cost. Anyway, we have done it. I mean, state done it. 30th rule has been published in the morning. 30th advertisement has been made. Because 31st May was the cut-off date. We have complied with the order. Therefore, my submission, kindly similar, why I am submitting. That's the reason I wanted to say, give me, I will try to. This may be accepted, may not be accepted, that's a different. Saying about that, no. Tainted have been totally discarded even by 31st May order, this order, 17th July. This is incorrect submission. Factual position is this, they will be there. Only untainted candidate service will continue up to 31st. That doesn't mean that the Supreme Court has cut a bar. No, tainted candidates will not be allowed to sit in the examination. Anyway,
after holding that there was an egregious fraud in the matter.
My lord, can I say, since your lordship have said, let me take it. Since it is a fraud, their appointments have been terminated.
With the direction to refund salary.
No, please. Kindly read this paragraph again. Refund salary to whom? No. Kothay dao? Refund salary ta? I am reading it. Paragraph 40, 45. Kindly read. The last question, paragraph 48. The last question relates to relief and whether it requires any modification. We find no valid ground or reason to interfere with the directions of the High Court. The service of the tendered candidates or appointed must be terminated and they should be required to refund any salaries, payments received such their appointments were the result of fraud. This amounts to cheating, therefore we see known as very nice.
So
Correct. Your lordship is correct.
Yes.
Now,
So thereafter,
now
they have to be
let
treated as a candidate to
let
apply.
let me explain. Let me explain. If your lordships read this entire judgment, your lordships will find it has been said that the Evidence Act doesn't apply. Correct. It's an inquiry naturally in a domestic in character. Whole inquiry. Charges have not been proved by anybody. It's a finding on the basis of this reports of the tainted, untainted. Court has not said the charges against them in a criminal court have been established. On the basis of a report on the OMR sheet, tainted, untainted has been given. Now, kindly see the judgment, paragraph 50. Our observation and findings would not influence the criminal proceedings. There was this observation for the temporal was for deciding that matter, not for future decision. Why should I not? Is there any conviction? Is there any conviction? Under what law they should be debarred?
Mr. Bandyopadhyay, it is worse than dismissal from service.
Which one?
This observation and
Dismissal. When your lordship has come to this,
which would include
my lord, kindly see.
future disqualification.
No, kindly this.
Since the appointments were the result of fraud, this amounts to cheating.
Kindly see. Dismissal with no appointment should be given. It should be governed by a rule.
And by making an rules dated 29th of May 2025, this untainted candidates have been permitted again to apply.
Yes,
and they have to get their marks for 10, which
I
has
am
been
coming,
allotted
one
for past service.
One by one, I have to come, I have to come one by one. First is the dismissal. When a dismissed service cannot get an appointment, if there is a rule, it has not been said dismissed from service, terminated from service. Compulsory retirement and dismissal is not same.
So that's why I have consciously used the terminology dismissal.
Therefore, this order has not been dismissed. Their services are dismissed.
Terminated for cheating and fraud.
Terminated. Cheating and fraud. With an observation, this observation will not influence the criminal proceeding. No conviction. There is a single case of no conviction. But this is our submission. Court, whatever the court will say, that's a different thing. That's the different part. This is our reading, we are saying. We have opened the door for all. Let's
how that is permissible in view of this.
Why not?
How in view of this order?
Supreme Court has not said. Supreme Court has not said.
And moreover, Supreme Court has not interfered with the judgment of the Honorable Division Bench dated April 2024.
Division Bench judgment has been merged with the Supreme Court.
Yes.
Justice Bosak has already made an observation in content petition.
That is merged.
Our observation has been merged with
Supreme Court has not deviated from the.
No, Supreme Court has but the Supreme Court has not said that the only unemployed, only untainted candidates will be given the chance. Had it been said, I would have accepted this. If it is interpreted, only untainted candidates will get the chance. In that case, neither tainted nor unsuccessful candidates will get the chance.
So what is the difference? If I accept your submission in connection with the observations made by the Supreme Court in paragraph 49, the difference in between tainted and untainted is for tainted, they will not get age relaxation.
Age relaxation.
For untainted, they will get age relaxation.
Why, Willard? I am saying, whole lot will not come.
In view of this, in spite of this observation of cheating and fraud.
My lord, yes, I have to read paragraph 49. I have to go by paragraph 49. What I will follow? I will follow the observation. Direction part. Direction part I will follow. Whatever the direction is there, I have to follow. I cannot deviate from the directions. I am just following the directions. My lord, kindly excuse me for saying, with great respect, that if there are two interpretations are there, one of the interpretation, if it's right, that
now another issue which is troubling this court, Mr. Bandyopadhyay.
My lord,
come to this rules.
All right.
Dated 29th of May 2025. Rules of dated 29th May.
Prior to that, your lordship,
I will hear you.
Just one disqualification I will just show to your lordship. Our rule. Then I am coming. Kindly excuse me. 3.5. Rule.
Rule. Yes. Yes, 30th May 2025 is the notification and rule is 29th of May. Just a minute.
3 rules, sub rule 5.
Just a minute. 8.
102. I am told one.
Just. Yes, 29th May.
Rule. 29. No person shall be eligible for 3 Roman 5.
3 Roman 5.
These are the disqualification.
Yes.
No person shall be eligible for selection for appointment unless he is a citizen of India. B. No person shall be eligible for selection for appointment if he is convicted by any court of law.
Yes.
Conviction, if there is a conviction. But years together, 5 years, 4 years, matter would be kept pending in the criminal cases, and the citizens, boys and children of these people of state of West Bengal will be remain in a limbo condition. Is it acceptable also?
Now, Mr. Bandyopadhyay, please come to Schedule 1.
Yes, my lord. 108.
Then Schedule 2, not Schedule 1, Schedule 2.
Schedule 2, 123. Yes, academic.
Then written marks, the marks which were allotted previously, that has been changed. Previously, it was.
Kindly come to me, that written examination OMR.
Previously, it was 55 plus 35 plus 10. Now it is 60 plus 10 plus 10 plus 10. 60 now, if court proceeds on the premise that it is within the domain of the recruiting authority to frame rules in rules, court will not enter into this issue. But what is pinching this court is this. Yes. Come to Schedule 1, this prior teaching experience 10. Please see prior under Schedule 2, then capital A1, 2, 2A, then 2B, prior teaching experience 10.
Yes.
Have you found?
Yes. Prior teaching experience 10 marks.
So written examination 60 marks, then academics 10 marks.
Yes.
Then apart from 10, oral interview 10, lecture demonstration 10. Very good. Prior teaching experience 10. That these tainted candidates who have lost their job by the dint of the order of the Honorable Supreme Court judgment dated 3rd of April 2025, with an observation that they are the product of cheating and egregious violations of the law, they are to get the benefit of this prior teaching experience.
Can I say?
Yes.
Mulad, if the question is, once you have tainted, then you can't get any chances in life, then it's a different thing. That you hold it. Once it has been declared tainted, this generation, these people will never get a chance to record it. I don't mind. I will say to that. But according to me, and this 10% rules is not a new one. It was earlier also there, pre-2016.
No, I am not questioning this rule. I am questioning that if this candidates are to be permitted by submitting application to be considered, then whether these tainted candidates are also going to get this marks of 10 for their experience in
doctrine,
past service.
I hope your lordships know that de jure doctrine. Suppose a district judge appointment is dismissed or appointment is held null and void or cancelled by the judiciary, his judgment will go.
That whether the situation is equated with this.
I am talking about principle of law.
It's not a similar situation.
I am talking about principle of law.
When the Supreme Court in paragraph 45 onwards has specifically directed.
Your lordship hold it. I don't mind.
Directed.
Your lordship hold it. I don't mind. But I am kindly see. Let me be very clear to your lordship. I am open to all. It's an open category. Whoever will succeed, whoever will not succeed, they will get the appointment. So far, the age relaxation is concerned, only the untainted candidates will get avail. Neither the tainted candidates nor the unsuccessful candidates will get this chance. All the candidates will not get the chance, as if all tainted candidates are coming. No. Answer is no. Have they given in the petition how many tainted candidates will get chances?
No, anxiety of the court is this, that the order of the Supreme Court has to be followed in its true letter and spirit.
My lord.
Where Supreme Court has said that these benefits are to be granted only in connection with the next selection process, which is confined to the, not in the same language, as it appears that it is confined to the untainted candidates. Then where is the bar you have claimed in your rules or in your notification that tainted candidates will not be permitted?
My lord, I do not read, kindly excuse me, my lord, just with greatest respect, deepest respect to your lordships, my lord, with deep respect to your lordships, my lord, I do not read the lines that the tainted candidates have been debarred to appear in the examinations. Tainted candidates.
Tainted.
I am submitting, my stand is very clear. My stand is, it is open to all. Open to all. Unsuccessful, tainted, untainted, everyone.
Very well, Mr. Bandobad. And I have noted your submission and any other point.
My lord, and kindly note that if it is said, so far 2016 selection process, only the untainted candidates will avail the opportunity, then tainted and unsuccessful, all are barred.
Yes, any other?
Can there be double punishment? Article 20, Article 21. Refund of salary has been made. Service has been terminated. Finished. No age benefit. Now, can they not sit in the examination with competition? Only these persons will be benefited. Those who are did not get the chance. Because here they are the litigant. Only the litigants will get the benefits.
These 2 points you have argued in details.
Yes.
Any other point?
Any other points means, I have to argue. If I have to argue to the rules is rule.
No, regarding I am expressing my mind.
My lord.
So that in order to cut short the interview.
Yes.
Regarding this allotment of marks and this 40-45% court will not enter. It's a policy decision. Court will not enter into this issue. What is troubling this court is whether the tainted candidates will be permitted to participate or not.
Yes.
That I am hearing you. And please address this court on the point that how far this court can go with in view of the order passed by the Supreme Court on 17th April 2025 fixing time.
But my lord, first of all, my lord, kindly just excuse, since it's a discussion aware. Your lordship is finally deciding the matter, or?
Yes, I will finally decide.
Okay. Now, my lord, my submission would be, I have made my first submission regarding tainted and untainted. The court will not interfere. If the court interferes, then the my lord, that 3rd July, 3rd April order will be interfered with. We will not be able to do it by 31st December, whatever it may be. And the persons who are appointed in view of the Supreme Court's order, they have to go. After 31st December, I cannot.
If the time schedule is extended.
If your lordships can do it, can't do it.
No. Court will not going to extend the time schedule.
Then these questions we will not discuss, because it will be discussed in the Supreme Court. It will be discussed in the Supreme
But certainly court can enter into the arena where court finds that a Supreme Court order is not being complied with in its
Sure. If your lordship strikes up,
maintaining the time schedule.
My lord, kindly see, if your lordship hold that this rule is bad, your lordship can strike it down. I am not saying that your lordship doesn't have the power. We have been asked to file an affidavit, we have filed the affidavit. There is a proceeding, my lord, pending before the Supreme Court under Article 32 of the petition, challenging the same rules. Filed on 10th June 2025. Details proceeding, a petition under Article 32 is there. And also an contempt petition has been filed. Whether we have violated the Supreme Court judgment order. The inquiry which your lordships are making,
thinking that keeping this selection process alive in terms of the time schedule fixed by the Honorable Supreme Court, court can debar the tainted candidates from participating.
Therefore, your lordship invalidating the rule in another way.
In order to maintain, in order to for the purpose of strict observations of the strict compliance of the directions of the Supreme Court.
My lord, that's your lordship. My lord, then in that case, your lordship, if your lordship hold that the
that is what court is thinking.
Court is thinking
that without, because court cannot tinker with the. You are absolutely correct, Mr. Bandyopadhyay, that court cannot tinker with the time schedule fixed by the Honorable Supreme Court. And what you have said, that is also to be taken into consideration. If time schedule is extended, then these persons who are untainted and those who are appointed, whose appointments have been extended till 31st, they will lose their job. So therefore, within the parameters of the order passed by the Supreme Court, as well as taking note of the steps taken by the recruiting authority relating to issuance of recruitment rules as well as recruitment notification, court can debar the tainted candidates from.
My lord, kindly, if your lordship doesn't accept my submission,
yes,
kindly accept one submission, that accepting untainted candidates, no one can make the application. In that case, whether tainted or whether unsuccessful candidates.
Accepting untainted candidates.
Whether it is a tainted or whether it is unsuccessful, they also cannot make application. They cannot also make this, because their party has not been scrutinized. Scrutinization only for so far that party. If your lordships, kindly excuse me, Miller, if your lordships holds it, although I have a total disagreement, with great respect, I have a disagreement.
That you can always.
I have with great respect, I have a disagreement.
Yes.
If your lordship hold it, that paragraph only gives the chance to the untainted candidates with age relaxation to apply. In that case, neither the tainted nor the unsuccessful candidates also can make the application. If you lord, but I am submitting, it is open to all, only
your interpretation is in connection with paragraph 46.
Yes.
We have submitted.
And my lord, in that case, your lordships would be imposing double punishment. Already one punishment, termination, and the refund of the salary has been made. How many times these persons will be victimized? I mean, how many times these persons will be penalized? How many times? Your lordships have.
If they are the product of fraud and cheating,
They are the fraud of.
They have to face the consequences.
No, fraud and product. That's the reason they have faced the consequences. Therefore, your lordship, if your lordship suggests that no, once you have imprisonment of 3 years, you are not entitled to enjoy any facilities of the society. Does it not violate Article 21 of the Constitution? My submission would be, once they have been tainted, their services have been terminated, they have been penalized to refund their salary, finished, chapter is finished. If they are no age relaxation, if they are eligible according to the qualification, I mean experiences, that the age criteria, they will sit in the examination. Thereafter, another things will be seen. These are my submissions.
Yes.
Only, my lord, I am very limited to your queries, lots of queries.
No, whatever I will go to that extent, I have indicated.
I have given the answer. I hope anything is left on. Anything is
deep into the matter, then I will.
Of course, anything.
No.
If anything is left for your lordship that I have not given the answer to your queries, your lordship can ask me. I will try to. My point is very clear.
Yes.
My lord, just give me the constitution. Give me one constitution. Just kindly give me 1 second. Constitution. Just give me one. Article 20 of the Constitution first.
Article 21.
Article 20, sub-article 2.
Just. Yes, article.
No person shall be prosecuted and punished for the same offense more than once. This is the, my lord, the constitutional philosophy. How a person can be punished for ever, twice, thrice, fourth time? How? Then, my lord, kindly come to 21A. The state shall provide, no person shall be deprived of his life or personal liberty except according to procedure established by law, under which law they are debarred to sit in the examination.
Yes, Mr. Bandyopadhyay.
বললাম তো আমি না সেটা বললাম তো আমি বলেছি the who cannot sit, that has not been said. If you again, আমি বলেছি দেবাঞ্জন বারবার তোর একটা জিনিস রিপিট করিস। I have said, I have again, if 49 paragraph is read to this extent,
then tainted without age relaxation, untainted with age relaxation.
Yes, and only this
if untainted, and the reverse situation is this: if untainted are to be allowed, then tainted along with unsuccessful are to be excluded.
Excluded.
Yes.
Yeah.
Yes.
বলে দিস developed. Sorry.
No, why sorry? I have fixed the matter for you to hear you. And Mr. Bhattacharya as well as Mr. Mitra. If I go beyond this, Mr. Bandyopadhyay, I will give direction for affidavit. But if I dispose it of,
I have only given answer to your lordship's queries, nothing more than that. Your lordship, your lordship's judicial inquiry is very limited.
Yes.
Am I right?
Yes.
Then I have given the answer.
Yes, Mr. Doctor.
I'm not very bad man.
Who says you are bad man?
Sometimes
Nobody is saying.
Sometimes your lordship says.
No.
That's it. I'm just coming.
Milord, 2 or 3 submissions. First is, Milord, the court is being invited to interpret the judgment of the Supreme Court. Where the Supreme Court judgment is clear in itself, a court is not called upon, or a high court is not called upon to interpret a judgment of a higher court. What is the meaning of that judgment? What Supreme Court wanted to say, what Supreme Court did not want to say, where the Supreme Court is silent, why it is silent. So these are things which are not to be argued before a court. But my second,
If there is any confusion or any interpretation is required,
yes,
if the judgment of the Supreme Court is crystal clear,
yes,
and no interpretation is required, then whether the High Court cannot pass order based on the order passed by the Supreme Court, Mr. Datta.
Supreme Court's orders are to be followed. The law laid down by the Supreme Court.
If some room is left open for interpretation, then court cannot enter into that arena. But if no room is left and the order is crystal clear, then where is the question of interpretation?
Right. There is no question of interpretation of the Supreme Court's order. Why? I'll tell your Lordship. First is, your Lordship has been burdened, kindly permit me to use this expression, to find out what is the fate of the tainted candidates. But I am not arguing for anybody, favor or against.
Yes.
What is the fate of the tainted candidates? Can the tainted candidates participate in the proceeding? The Supreme Court has not granted age relaxation to them, though age relaxation has been granted to the untainted candidates. The Supreme Court order judgment does not say that they will not be allowed to participate. Why? I'll tell your Lordship the reason. The Supreme Court punishes the tainted candidates by saying that refund your salary. Supreme Court does not say two things expressly. One is that the tainted candidates are debarred from participating in any future recruitment process. And the Supreme Court does not say that the teaching experience will be taken away from their career for all times to come during this period. Now, why this? Well, under our constitutional scheme or under the laws of our country, we do not have a right of employment. There is no right of employment. The only right that we have is to have a right to participate in the selection process, provided we meet the eligibility or whatever criteria. This is the minimum right. And the corollary to it is that if I offer my candidature for a particular post or in a recruitment process, I have a right to be considered fairly with the other eligible candidates. That is why all these questions of transparency, lack of transparency, opaqueness, tainted, untainted, why have all these got generated? All these, in my humble understanding, is a fair right of participation has been taken away from some persons and conferred it to some untainted, tainted people. Therefore, the basics we cannot miss. The basics is that a person, even the biggest criminal of the country, has a right to participation. Number one.
Yes.
For the time being, my lord, please keep aside the tainted, untainted issue. A right to participation is the minimum that we have, and the maximum that we have is a right to a fair consideration along with other eligibles. This is the dual basic jurisprudence in service matters. Therefore, my understanding, the Supreme Court did not make that observation or give that direction in the judgment that no tainted candidates will not be allowed to participate in future, because even under 142, the Supreme Court cannot violate a law. Though here 141 is exercised, not 142. Take the maximum extent. Supreme Court, while exercising power under 142 extraordinary power, there also Supreme Court has to confine itself within the four corners of the law. The four corners of the law is that nobody, if eligible, as per the rules, can be prevented from participating.
Right of participation cannot be taken.
Cannot be taken away. Therefore, if today an argument is advanced before the court that tainted people, whether they are party to the opaque process or corrupt process, whatever has been term used, if it is held or if the court is invited to make a declaration of law that once found tainted, he or she loses right forever to participate in a selection process, Millard, will be contrary to the basic service jurisprudence of our country.
Yes.
Therefore, Millard, the Supreme Court was conscious in not giving this direction.
But Mr. Dotto, this court is not considering the future ramification. Court is considering the ongoing selection process which is being conducted in terms of the order dated 3rd April 2025, read with 17th April 2025. Why court will enlarge the issue unnecessarily?
Yes. May I say this? As I started by saying that the
you may have invited this court to make an wider interpretation or wider observations, but court will restrict it only to the holding of selection process which has been initiated in terms of the order dated 3rd as April 2025, read with 17th April 2025.
Milord, I have started by saying that the court cannot be invited to interpret a judgment. But since the arguments are such that I have to make some submission which will finally lead to inviting a lordship to interpret the judgment, but I am compelled to make that submission. The submission is the tainted candidates have been told that there will be no age relaxation for them. There is no dispute on that. When does the question of granting or not granting age relaxation come? This issue or this occasion can arise only, apropos the subject matter of dispute, in a selection process. Otherwise, the question doesn't arise.
Yes.
Therefore, age relaxation is permitted or not permitted by a rule. Here, the Supreme Court, exercising its powers, have said this category will get age relaxation, disabled will get, tainted will not get. Where will it not get? But again, my lord, I am bordering on interpreting a judgment. Though I am saying that the court cannot be invited to interpret a judgment, but the argument is such, I am compelled to make this submission. When the court says that no, you will not get any age relaxation, the court is saying that in a case you want to participate or you get an opportunity to participate, and if you are overaged by that time, sorry, others will get, you will not get. Then what will it lead to? When the Supreme Court says that no age relaxation, it means that in a possible selection process or in a selection process pursuant to the Supreme Court's order, those who get aged barred, they will miss a chance. The question of granting or not granting the age relaxation in a service matter has to be connected with a selection process for appointment or promotion or whatever. Therefore, my lord, in other words, the dual effect. Number one, Supreme Court does not say that they are barred, because that would be contrary to the basic jurisprudence. Number two,
Yes.
Number two, the indication that tainted candidates will not get age relaxation itself is a precursor or an indicator that the Supreme Court will debar them in a selection process if you get age barred. But otherwise, my lord, that direction or that portion of the direction becomes meaningless.
That is also the sum and substance of argument advanced by Mr. Bandyopadhyay.
Yes. So it has
So
to
for
be
10 candidates without age relaxation, for untainted candidates with age relaxation.
Yes, but I was trying to, my lord, impress upon your lordship, my lord, from a different angle. An issue of age relaxation, granting or not granting, is always connected to a selection process. So if the Supreme Court was not contemplating a participation for the tainted candidates in a possible or a future selection, my lord, the question of somebody getting age barred or not age barred doesn't arise. Therefore, my lord, please consider this angle also. Taking away a right to get age relaxation.
Your submission in other way is this: if untainted are granted liberty to or were directed to participate with age relaxation, that indirectly permits tainted to be considered without age relaxation.
Well, a bit different. My submission is, well, I confirm, because there is no dispute with the untainted candidates. Therefore, my lord, I will not trouble your lordship with that. What I am saying is, when in respect of tainted candidates, the Supreme Court says that he will not get age relaxation, what could be the reason? But Supreme Court is not going to pass any direction in vacuum. For the tainted candidates, the observation or the direction that he will not get age relaxation means that the Supreme Court is abreast of a possible selection process, because the state had said that all my schools will become teacherless. Therefore, I have to go for a recruitment drive. Therefore, the Supreme Court has framed a milestone sort of a thing. Yes. So it is not that the fallout or the aftermath of the Supreme Court direction is only to be confined to the untainted. It is left to the rest of the world, all participating or eligible, age-wise, qualification-wise, etc. Therefore, my lord, the tainted candidates, to my understanding, again, my lord, bordering on, my lord, interpretation of a judgment, is that the tainted have not been debarred. They are only robbed of a right of age relaxation. So, there has to be two categories. So this would be, my lord, my first submission. Oh, একটা 15 বেজে গেছে।
No, you continue. I'll conclude it.
Well, so, my submission number 1 is, court cannot be invited to interpret a judgment. Submission number 2 is, in the alternative, assuming that in a case there is some, what should I say? I won't say vacuum, but there's some scope of interpretation. Then also, my lord, this should be the interpretation as I have submitted. I do not know, my lord, whether my learned friends are still pursuing the challenge to the rules or not, because my fundamental argument will be on the rules. Because Mr. Mitra, I am told, my lord, has made a lot of submissions on.
And he has not pressed on the prayer whereby declaration was sought for, declaring that rules ultra vires.
So we proceed on the basis that the rule is
But
not.
Mr. Bhattacharya has submitted that they are challenging the rules.
Oh, then I have to make some submission. But first is, well, this is a rule, my lord, as your lordship has found, which has been framed, my lord, in exercise of powers, my lord, under the
That is only to the extent of 40-45% this change, because that is, according to Mr. Bhattacharya, is not in consonance with the observations made by the Supreme Court in previous order, because first of all, the submission of made advanced on behalf of by Mr. Bhattacharya is this, that these vacancies which were earmarked for 2016 selection process to be kept separate, and for them a separate selection process, and that has to be in terms of 2016 recruitment rules. That is the submission. You may press into service this 2025 recruitment rules, but not for the candidates who participated in 2016 selection process.
That with respect,
and that too to the extent of untainted category.
My lord, in that case, my lord, my submission would be, my lord, that is not a challenge thrown to the rules. It may be a challenge to the applicability of a rule, whether it is a 2016 rules to apply or 2025 rules to apply.
But you, I think at this stage, as I have expressed my mind, you need not elaborate on this issue, because I am going to interfere to the extent of this untainted candidates.
Only to that extent.
Only to that.
Very well. Then, well, I don't think that I need to waste your lordship's time.
And since the time schedule is there, because that is not going to be tinkered
No,
with.
that will not
So
be,
therefore,
of course,
keeping this time schedule intact, only that these tainted candidates are not to be permitted. That is what this court is considering. Because other aspect, this is a policy decision, and also with regard to this, these vacancies. These vacancies are, if these vacancies are taken into consideration along with subsequent vacancies, this court finds that there is no fault. If there are 500 vacancies, and 300 vacancies clubbed with another 300 vacancies, then 800 vacancies can be considered.
But then I will not
tainted candidates, I have reservation with regard.
Yes, I made my submissions on that, your lordship.
Now that I take the cue of that advocate submission, they are inviting the court to interpret the judgment of Supreme Court. I do not invite. I say read the judgment as it is. Kindly will once again point out Supreme Court. আমার briefটা কোথায় গেল? Brief নিয়ে চলে যায় কেন? Kindly will comes to the Supreme Court judgment in simple English language, and the Supreme Court, my lord, is the constitutional authority who interprets the law. That neither the state or anybody can say the Supreme Court judgment is not the law. What I understand is the law.
Yes.
There's a peculiar submissions have been made. I don't want to detail on that. And the extension of peculiar submission was Article 20 and 21, which are specific application for criminal cases.
Yes.
But anyway, let us see, my lord. Here, Lordship will kindly remember that the division bench of this court has said that this is quashed because of violation of Article 1416. That has been upheld by the Supreme Court. Supreme Court only modified to the extent, I am just reading the modifications.
Yes.
Therefore, the judgment of the division bench is the sheet anchor.
That was not interfered with.
Not interfered with. That's very important.
363 paragraph.
Yes. Now, kindly, my lord, comes to the relevant paragraphs which clearly indicate the tainteds were completely knocked out by the Supreme Court, the highest constitutional authority.
Yes.
Which does not require any interpretation.
Which judgment you are relying upon? 3rd April.
Bench, Supreme Court.
Supreme Court.
Yes, conclusion.
3rd April judgment.
3rd April judgment.
Yes.
3rd April judgment was not modified except to the extent permitting someone to continue till 31st December, again making difference between tainted and untainted. Well, kindly come to paragraph 46.
Yes.
For candidates not specifically found to be claimed, when the return of salary is paragraph 45, I'm not undermining. For not candidates not specifically found to be claimed, the entire selection has been rightly declared null and void. But this is not because of
Untainted.
All
Candidates not specifically found to be tainted. Yes.
The entire selection has been rightly declared null and void due to egregious violations of illegalities, which violates Article 14 and 16. Now, that is the fundamental thing we can repeat it. As such, the appointment of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their service will be terminated. Therefore, Lord, all these paragraphs should be read out in conjunction. First paragraph tainted, you go. Second paragraph untainted. You may not have to refund the salary, but your service goes because of Article 14-16 violation. Because no candidates can be appointed once the entire examination process and results have been declared void. No candidates could be appointed.
Where we are reading paragraph 46.
46, last two lines, very important. Therefore, it applies to all who can be appointed, then can we come to next. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state governments also. But in such cases, although their appointments are cancelled, these candidates will have the right to apply to the previous departments or autonomous bodies to continue service over the dictates. These applications must be processed by the respective government departments or bodies within 3 months, and the candidate will allow into their position. Further, the period between the termination of their previous appointment and the deployment.
That is not relevant. This part is not.
Since I say the interpret, I say no, interpret is called for. If you go step by step, Supreme Court was segregating the categories.
Yes.
Here, the persons who were already appointed.
For them, different directions were given.
Then kindly come to the disabled. Last is important. We address the candidate of disabled candidates. Our attention has been drawn to one such where review judgment helps the appointee to be allowed to continue on limited grounds. Why? We will not interfere with this finding. We will make it clear.
Other
different disabled candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. Even disabled candidates, when they appear personally before the court, when the Supreme Court doesn't violate them.
Because disabled candidates may be termed as tainted also.
Yes. However, in consideration of the disability, this category permitted to continue and will receive wages until the fresh selection process according to the completed. Then, the disabled candidates, 49, mentioned in the previous paragraph, will be allowed to participate. If disabled candidate in fresh selection process, if required with age relaxation and other concessions.
That is all disabled candidates.
Including tainted and untainted. Then, similarly, other candidates who are not specifically tainted will also be eligible. Therefore, without they are keeping it will separate from the tainted candidates. And for them, the benefit is to appropriate age relaxation. In our opinion, such direction would be fair and just as it would allow these candidates to take part. These candidates means below the disabled candidates and the non-tainted candidates with age relaxation, which should now be initiated. Therefore, it's very clear. It does not require any interpretation. It's clear language.
Yes.
One sentence, there is a comma.
Yes.
A comma after eligible to participate. So the category created by the comma.
Last sentence.
Yes.
Paragraph 49.
49 are not specific.
In our opinion, comma, such direction would be fair and just, and as it would allow these candidates to take part in the fresh selection process, which should now be initiated to fill up the vacancies.
Therefore, the Supreme Court, in clear terms, reverse the fantastic argument of Inroading, double punishment. What is the double punishment? Single punishment.
So let us not dilate on this.
And another thing which the rules, Lordship is not going to the validity of the rules, but this will create a class amongst class. If you allow the fresh candidates and they say teachers will be getting 10 marks, which will have to make it absolutely imbalanced. and arbitration. And if they are allowed to participate, the point you just said from the court, the legal section earlier, then they will get the benefit of 10 marks.
Yes, that I have said.
If the
The
appointment.
tainted candidates and whose appointments were nullified by making an observation that these are the product of cheating and fraud, their service which they are rendered, that is to be considered and they are to be given 10 marks.
Suppose when the highest court declares them void, and you say I will give them the benefit.
Yeah, আমি ঠিক 5 মিনিট আসছি ইস্যু ডিকটেশনটা দিয়ে
10 marks.
I'm coming back 5 minutes. I'll start dictating.
Item number 247.
Your Lordship, Ms. E.T. Datta is appearing for the respondent in this matter, Your Lordship. Ms. E.T. Datta is appearing for the state respondent.
Time of call. One application.
From 3 o'clock, a different bunch is to be called. This is the 2 o'clock bunch.
Right. From 3 o'clock or 3:30? If it is 3:30, then it is now 3 o'clock. Huh? দেখি এখন তো বলে কিন্তু মান তিন কাটা ধরবে যে বহানো তো একটা মোশন
Is this corona?
তো চেম্বারে কে এসে হয়েছে 3 PM তে দাঁড়া 3 PM তো আর হয়ে গেল টাইম 2:47
3 PM.
3 PM Yes. 47. Yes. From 2:47 matters to be taken up, right? But you have, it is your duty to point it out. It has to be checked. Otherwise, it is difficult. 2:47 onwards from 3 PM.
Yes.
So now the time is 3:52. So therefore, 2:47 onwards.
I'm appearing for the state respondent.
The time of call, no one appears for the petitioner and no accommodation is grateful. I was state president. You are for the existing.
No, not really.
I was state respondents and represented by non-advocates, advocates, restrictions and dismissed for default. Part 52, act on the server. Next.
Item number 2. Your Lordship, I am appearing for the petitioner, led by Mr. Shubhangshu Banda. This matter relates to interest on area pension from CPF to GPF. The matter is
Record and all. At the time of all learned enough, publics that touching upon similar issue, happily spending the foot on our issue. Next one. List the matter under the same heading in the monthly combined list of September 2020. Next.
item number 2. Same matter, Your Lordship.
Interest on 8-year pension after conversion.
Yes, yes, from CPF to GPF.
Same order, September 2025.
Item number 250.
I am appearing on behalf of
Your
the
Lordship,
chairman.
it is also a same.
Dr. Patro, today's schedule gets affected. Yes. Same matter.
Yes, Your Lordship.
Same order, September 2025.
Monthly list.
Item 251. Your Lordship, same matter.
September 2025.
Item number 252. Same matters, Your Lordship. Grateful, Your Lordship. Item number 253.
Yes.
We are pending before the division bench. Madrasa matter, my lord. Yet preference. Yet preference matter. Madrasa matter issue has been pending before the division bench.
Yet preference matter.
Petitioner is a yet candidate. Yet candidate petitioner. Some of the until candidate get preference and we got appointment. Then some of the candidate paper petition before the Honorable High Court and order annex page 68.
Who is for the commission?
Madrasa.
West Bengal Madras Service Commission, when the panel expires? When they have filed the petition?
2023.
27 September 2020.
Yes, your lordships, one matter dismiss on paper appeal, and that appeal has been pending before the division.
So what? Let me, that does not divide this court from proceeding. Let that my order be tested before the appellate court. But since till date my order remains, I am to follow the same order. Month by month, same order can and usual order cannot be passed by keeping your writ petition pending. Yes. If it is submitted by the learned advocate representing the petitioner that the intra-court appeal being MAT 551 of 2025 within bracket Somendu Chattopadhyay versus State of West Bengal and others is still pending. Next paragraph. Let the matter go out of list with liberty to mention. Next. That Somendu Chattopadhyay matter is still pending.
Item number 254. I am for the petitioner, my lord. Item number 254. On last occasion, your lordship pleased to pass a direction upon me to added party the commissioner of school education, and I have added party and serve him.
Just a minute.
Lordship.
At not. At the
Where is Mr. Suman De? He appeared on the last occasion on behalf of the state respondents.
Yes, my lord.
Court directed the Commissioner of School Education to file a report. Then I have to give direction upon the Commissioner to remain present. Where is Tonuja Bashak? He is also appearing for the state respondents. She is also appearing for the state respondents. Where are they? Pass it over. Miss Dotto, inform Mr. De.
No.
Yes, call the next matter. Pass over.
Item number 255.
Lord, I beg to appear for the
For
petitioner.
the
in this
respondent number
matter,
8, my lord. I appear on
Am I
behalf of the
audible to your
petitioner.
lordship?
Lord, I appear for the respondent number 11 to 14.
Lordship, on the last occasion, there was a direct.
Last minute.
Lord, am I audible to your lordship?
Allow for the house advocate. Important advocate.
Lord, am I audible to your lordship, Lord?
Where is the supplementary affidavit?
Already served the copy of the supplementary affidavit.
Now, in which classes their words are studying?
Lord, am I audible to your lordship, Lord? Lord, am I audible to your lordship?
What is leading me? He is appearing online.
They are audible but not visible.
Lord, I do not understand, Lord. I have switched on my camera, Lord. That's Lord. Kindly permits me, Lord, to make my submission, Lord.
Yes.
Yes. Lord,
In
on the
which
last
case,
occasion,
which
my Lord,
classes words are studying?
my Lord, kindly comes to page number 3 of my supplementary affidavit. But I'm grateful for permitting, Lord, to appear, Lord, this way. Lord, I have indicated your Lordship would find a chart at page number 3. Lord, petitioner number 1, his what studies in class 8. Petitioner number 2, Lord, what studies in class 6. Lord, petitioner number 3 and 4, Lord, 2024, what had Lord completed his academic tenure, and 25, Lord, this Lord, with respect to 5, he is studying in class 12. So, Lord, out of 5 petitioners, Lord, 3's words are already there in the school.
So therefore, expunge the names of 3 and 4.
But that your Lordship, Lord, will pass an order, Lord, we shall do the need.
First
Now,
expunge
Lord,
the name.
here is-
First expunge the names.
Very good. Lord, as your Lordship pleases, Lord, there is no difficulty, Lord, in that. Lord, we had filed this application, Lord, in 2023. Unfortunately, Lord, for
Sure.
some reason or the other. And
Supplementary
that
affidavit
juncture,
filed
they
on
had, Lord, there.
petitioners is taken on record. Stop. Next, paragraph on perusal of supplementary affidavit, it appears. Get a petitioner now. Could be Raghunath Chakravarti. Appears that petitioner number 3 and 4. Now, it appears that words of petitioner number 3 and 4 passed class 12 final examination. Therefore, words of petitioners number 3 and 4 are no longer students of the school in question. Next paragraph, leave is granted to the learned advocate for the petitioners to amend the cause title and expunge petitioner numbers 3 and 4 from array of writ petitioners by tomorrow, 8 July 2025. Next paragraph, list the matter under the same heading in the monthly combined list of August 2025.
Lord, may I pray for only one thing? Lord, may I pray for
Pray,
two
let
things?
the-
But
let
only
the
one
restitution
thing, my lord, I need to indicate, your lordship, that I am appearing for the headmaster.
Come back on the next day.
But I just 1 minute. But I am appealing for the headmaster. I shall be retiring on 31st July, my lord. There are certain allegations, my lord, which needs to be dealt with. But kindly allow me to file my opposition in the meantime. But I shall be
But
retiring.
because I won't be praying for any scope of, there is no scope of interim order. So, my lord, your lordship can direct,
With
Lord.
regard to your retirement, it is not connected. It is not
Certain
connected.
allegations are there, my lord. I want to
Next matter.
Lord, only one more thing, Lord, the renumbering
No other
has
thing
to be
at
done.
present now, please make the writ petition in order, come back.
Item number 256.
I beg to appear on the petitioner. The petitioner being an honors graduate appointed in the year 2010. And thereafter 2011, when he completed the final MSc examination, he got the certificate and thereafter he applied. Did not consider, I moved this Honorable High Court. This Honorable High Court allowed this application. And in contempt proceeding, the contemptor respondent, my lord, appear and my lord.
Higher scale of pay for enhancing which qualification?
MSc.
MSc in relevant subject. Now you applied for, then it was considered by the DI.
No.
Then what happened?
That was pending. I moved this Honorable Court. This Honorable Court, my lord, allowed. Since my lord, I am my lord honors graduate, my appointment was honors graduate. And thereafter, in contempt application, my lord, the respondent contemptor appeared and my lord.
What was the order passed by the DI?
Page 34. Earlier.
Page 34.
34. Well, I passed my earlier.
That is the order passed by this court.
Yes, yes.
Then court directed DI to consider. Just a minute.
No, no, allowed.
Allowed.
Oh.
In at page 2. Page 35.
Who is for the state?
I have served, my lord, pursuant to my lord's direction.
Bhaskar Prasad Boisho and Ranjan Shaha for the state. Where are they? And Minal Kanti Ghosh.
Yeah, I served Minal Kanti Ghosh.
Three advocates, none of them are, none of these three advocates is appearing.
Well, I missed the list. Sorry.
Yeah, Chiro.
We hired.
Oh.
আচ্ছা
পরে আমি ও ও ও ভুল হয়েছে তিন আমি জিরো
Yes, then what thereafter what happened?
What when district inspector school, my lord, gave an undertaking, that is page 37.
Yes, what is the wrong in it?
Well, thereafter he revised. The district inspector revised the pay scale. Well, kindly come to page 46.
Granted from the last from the date of publication of result.
Result.
Rightly
Thereafter,
done.
47. That was not done. My lord, kindly see page
No, no,
47.
it has been granted hereby accorded to the petitioners for obtaining postgraduate degree with effect from the date following the last date of MSc final exam. Last date of MSc final exam.
That was not done actually, my lord.
That was not given. Scale was not
Given
given.
effect.
Then
That
what
was
happened?
page 46, my lord.
46.
One pay, my lord, for the month of July 2003, pay scale was, my lord, fixed. But no, my lord, area, nothing. And thereafter, it is withdrawn, my lord. Next page. 47.
So, in effect, benefit of postgraduate scale of pay has not been extended to you.
Yes.
Not. Court directed, then DI passed an order.
45 contempt, it's an order of contempt court, my lord. Can you see page
Oh,
45?
contempt proceeding was drawn up.
Yes. And it said, my lord, order has been complied
Page
with.
45.
Page 45. It said order has been complied with. Subject to.
আচ্ছা নোট করে নেই কেন জানি না
What remains?
Undertaking was subject to, my lord, appeal, pending appeal.
No, it has been, contempt proceeding was dropped. If appeal is pending, contempt proceeding is not dropped. Contempt matter is generally directed to go out of list, subject to the result of the appeal. No, but there's a counsel on behalf of the parties submit that impugned order passed by this court has been complied with.
Yes, my lord, thereafter, my lord, the annexer, my lord, page.
No, what remains after that?
Only, my lord, month of July.
Accordingly, no further order is required to be passed in this matter. The contempt application is accordingly disposed of.
Yes, my lord, but ADR was not given to.
Yes.
To the petitioner. The only, my lord, pay slip for month of July 2023, my lord, given effect to, thereafter it is withdrawn.
Today you are seeking extension of benefit of higher scale of pay.
Yes.
That was granted by DI. You are submitting subsequently in effect. Pay was not upwardly refixed. You initiated a contempt proceedings. In the contempt proceedings, it was recorded that the counsel on behalf of the parties submit that the impugned order has been passed by this court has been complied with. What remains?
That is, my lord, in terms of page 37. Can you see?
Whatever may be the position. If in terms of page 37, if this was page 37, you are relying upon that is dated 9 September 2022 and contempt application was initiated on 22nd November 2022. Yes. Then after contempt application, any development took place, or prior to that, this higher scale was withdrawn.
No, after contempt application, my lord, the respondent, my lord, issued the pay scale for the month of July 2023. And next day, my lord, it is withdrawn.
Month of July 20, this order was page 37 is 9 September 2022.
Yes, my lord.
So from 9 September 2022, this it was granted from the date following the last date of examination.
That is the 2011.
Date following the last date of MSc examination. Now you are submitting this. This was actually sanctioned.
Page 46.
If for the month of July 2023.
Yes.
Thereafter, it was not granted.
Then withdrawn. The next page. Fixation of pay in favor of the Subroto Bons 80 assistant teacher. In connection with the subject mentioned above, the undersigned has to inform him that the pay of Subroto Bons be fixed 60,800 without any
different thing. That is with regard to fixation of pay.
But my fixation was 62,600. Page 46.
That may be that your pay has been wrongly fixed. That has no connection with sanction of postgraduate scale of pay.
But there is no reason why
exchange affidavit. Yes.
That is not been challenged.
That is yes.
That is not been challenged. Withdrawn notification
in the prayer.
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. It is submitted by the learned advocate representing the petitioner that in terms of the order dated 27th April 2021 passed by a coordinate bench on a writ petition being WPA 21315 of 2019. Petitioner was sanctioned postgraduate scale of pay. With a memo dated 9 September 2022 issued by the District Inspector of Schools AC South 24 Parganas. Stop. It is also submitted that in view of issuance of memo dated 9 September 2022 granting postgraduate scale of pay. Contempt proceeding was contempt application was disposed of. Video order dated 22nd November 2022, but subsequently pay of the petitioner was downgraded by the by the said district inspector of schools. Video memo dated 28 November 2023. Stop. According to the petitioner, downgradation of pay of the petitioner amounts to withdrawal of postgraduate scale of pay, which was previously sanctioned with a memo dated 9 September 2022. Next paragraph. State respondents and West Bengal Board of Secondary Education are represented by learned advocates who have prayed for accommodation to use affidavit. In order to demonstrate that graduate scale of pay was not withdrawn after same was sanctioned, vide memo dated 9 2022. Next paragraph. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of service on the next day.
Right.
Let them demonstrate that how it has been.
Yes.
Otherwise, issue cannot be decided.
Item number 257.
I'm for the statement.
Petitioner PH. What are parts? The hearing matter. Who is for the petitioner? Mr. Bera. Where is he? At the time of call, no one appears. At the time of call, no one appears for the petitioner. And no accommodation is paid for. You are for the state. State respondents are represented by learned advocate. Next paragraph. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 258.
The Passover matter. Where is Mr. Dey?
He's on his legs in the next room. I have informed him.
258, my lord, Mr. Kanadal Samanth is appearing on
Yes,
behalf
my
of
lord, I am
the
appealing for the state.
He's engaged in another court, my lord, your lordship.
Last occasion, your lordship directed me to take instruction. Steps has been taken for payment of higher scale of pay, my lord.
Matter relates to grant of higher scale of pay.
Yes. Steps has been taken.
So it has been granted.
It has been taken in June. They have sent it. DI
What steps have been taken?
DI has requested the ADI to follow up the order and take steps for consider his claim according. The last bit.
Can you take it up on bottom one?
Yes.
না মিস করে না অন্য করে মামলা Second.
To let the issue be decided by the additional district inspector of schools. Already issue has been referred by the district inspector of schools to the additional district inspector of schools.
No, I do not have any knowledge about the matter, my lord. Just I have been informed over telephone that take time.
Telephone.
But he is engaged in another court matter.
And while doing another matter, he has called you.
That matter is to be going on and has not yet been taken up, most probably.
Issue. A matter is taken up for consideration. When prayer is made on behalf of the petitioner to adjourn the matter on the ground of the learned advocate. Next paragraph. However, state respondents are represented by learned advocate who has submitted a writing dated 18th June 2025 issued by the District Inspector of Schools AC Purbo Medinipur being respondent number District AC Purbo Medinipur being respondent number 3.
Yes, madam.
And same is taken on record. Top. On perusal of same, it appears that District Inspector of Schools has District Inspector of Schools has taken it by memo dated 18 June 2025 requested the additional District Inspector of Schools AC Contai subdivision to decide the claim of the petitioner for sanction of postgraduate scale of pay in terms of the judgment delivered by the special bench dated 7 February 2024 on a batch of writ petitions. First one being WPA 9921 of 2007 within bracket Utpal Kanti Karan versus State of West Bengal and others. Next paragraph. Therefore, it appears that the issue is pending before the additional district inspector of schools AC Kontai subdivision being respondent number 4. Next paragraph. Hence, respondent number 4 is directed to take decision on the claim of the petitioner to sanction postgraduate scale of pay following a ratio of Utpal Kanti Karan Supra by 4 weeks from the date of communication of this order. A reasoned order shall be passed by the respondent number 4 after granting opportunity of hearing to the petitioner or his representative. Stop. The decision to be taken by the respondent number 4 shall be communicated to the petitioner by 10 days thereafter. Next paragraph, writ petition stands disposed of, urgent xerox certificate copy. Nothing remains. It has to be decided first by the authority. Get.
Passover matter item number 254. I for the petitioner, my lord.
Where is Mr. Sumonde?
I have already informed him over phone, my lord, and he is.
Yes.
Yes.
Commissioner of School Education was directed to submit a report, Mr. De. And you are not appearing before this court.
I was just, well, I got a instruction, although it was prepared, but not
What is that?
to me that for in absence of hard copy service book, it has to be placed before the finance department. Now the DI has to make a formal prayer before the Commissioner School Education seeking this approval and placing the matter before the finance department. So the commissioner has directed.
No, issue is whether dispensing requirement of preparing and submitting service book, which is not available. Family pension can be granted in favor of the petitioner.
Yes, that can be granted. There is a provision. So for that, there is a there is a mistake by the DI that he has directly sent it to the commissioner, but he has to make a formal prayer seeking this.
So let us know from commissioner.
Yes, that has been.
What commissioner is saying.
But says that the DI will now make a formal prayer. They have to rectify the procedure.
We'll come back tomorrow.
Yes, my lord. Or my lord, after.
শোনো এই অঞ্জন এই দুটো জাজমেন্ট এখানে পুরো রয়েছে সকালবেলা দুই ম্যাটারটা বড় ইয়েকে পাঠিয়ে দাও শুভেন্দুকে পাঠিয়ে দাও একসঙ্গে আমার কাছে দিই
For 3 weeks after, I mean, it will take. My lord.
Let me consider.
Confirm, my lord, first. Grateful.
Great.